Let it come on for supplementing motion tomorrow, Lordship. We had some emergency, Lordship. Oblige, Your Lordship.
For permission for reader, Lordship.
Draw.
May I please, Your Lordship? Pray for listing of a repetition matter under motion column in the next week, my lord. Oblige.
May I please, Your Lordship? Lordship, next to mention item number 17. Due to personal inconvenience of Sahiwal study, Lordship.
Item
Consent-
number 17. Yes.
Consent of the other side has been taken.
You are for the petitioner,
And for the petition,
Mr.
J. Chopra.
From 72 years. Mr. J. Chopra, Learned Counsel, for the petition, has made a prayer for adjournment of the case. How much? After?
After vacation,
Okay, after 2 weeks. It is submitted by Mr. Chopra that consent has been taken from the Learned Counsel for the other sides, respondents, to make the prayer. As paid for, the matter stands adjourned for 3 weeks. Raise the case, office to raise the case after 3 weeks on the date to fix paid office. Interim order, if any, shall continue till the next register. Is there any interim order?
yes, Your Honor. Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a writ petition, my lord. Old matter, 24 matter, my lord. On the last occasion, 10/3/2025, there is a direction to the Revenue Department to file an affidavit, my lord. But till today, there is no affidavit, my lord. The construction is going on, my lord.
Okay,
Kindly,
next week,
after vacation, my lord.
after vacation.
Well, they'll kindly date. Oblige. Wait, Mr. Lordship, I beg to mention for listing of a writ petition, Lordship, it's an urgent matter.
Motion,
Motion, Lordship.
next week.
Lordship,
Monday?
Saturday, Lordship, because a boundary wall is constructed, Lordship, and the respondent is going to construct a boundary wall blocking all the pathways, Lordship.
Then tomorrow
Lordship,
or Monday.
tomorrow, Lordship. Oblige.
May I please, Your Lordship? Lordship, I pray for listing a contempt petition for Udall, Your Lordship. Tomorrow. So.
Supplementary list for hearing, items 18 to 49.
No, 9. That was equivalent. Any idea about Mr. Kumar? Respect this will do. From RC Palavana to D2. RC Palavana to D2. Yes.
Running well. But I have been informed by Mr. Kumar Lord, there are separate notification under section 31(1) that the Lordship has, as well as 65 creating Anjali Parishad and Jilla Parishad. So my query is on his way, my lord.
So that I can conclude.
Yes, yes. And one point of information, my lord, yesterday we issued a notification, my lord.
That I have seen in the newspaper. Okay.
It will take some time coming, Lord. He has been stuck up in traffic that have been informed. Your worship can take up some time.
I do not want to interrupt the other proceeding, that is
Yes,
why.
I understand once, Lord,
This is
in the,
sporadic,
and
intermittent disturbance is difficult for court to adjust. Okay.
I'm sorry, Lord.
Daily list for motion, item number 1.
Yes.
Instruction losses. Some cases are 6.7 losses. Here.
And Ms. Borua, how do you justify this? Page 66. A composite lead cell permission, order is found. There is a notification regarding
My lord, it is
composite land cell
CR lordship.
permission.
11th November 2022 lordship.
Composite খন্ডিবকালী. How do you justify this page 66? That application is rejected by ADC, rejected insufficient documents not submitted. Take it over. As per your composite land cell transfer. Oh, registration and conversion. What did you do? This is for what?
My lord,
The application was for what?
for
purpose?
selling land lordship. Mobile.
No,
mobile
no.
port.
Okay, composite
Yeah.
land cell transfer.
Yes, lordship. My lord, section 21 here is my lord,
I have-
nearly
I
amended
know.
lordship.
A component service, I must see. Yes, because. Oh, nowadays, who are the appellate authority, madam? Commissioner of Division is
Commissioner and Secretary.
Revenue. That notification somewhere you place.
My lord, citizens charter is there lordship annexure 1.
That I have seen. But for filing an appeal, he has to know the reasons,
Yes.
what are the deficiency in the documents. So suppose you put yourself in the position. It simply says rejected. Now there is an appeal. So if you want to file an appeal, you don't know the reason. On what grounds? You said simply sufficient documents not submitted. So what are the documents which are found to have been not submitted? That is also not recorded. And there is no separate provision for. We'll set aside this. use. File according to the, you pass order recording regions. If it is allowed, allowed. If it is rejected, then please mention what are the documents required. And if rejected, so that he can file an appeal. And that authority can appreciate whether those grounds for rejections are sufficient or not sufficient. Simply rejected, that's all. His right to property is also associated with it.
Similar matters are.
We are doing it. There has to be the beginning. We'll begin with this. Yes, Mr. Doctor, you have the same kind.
Same, my lord.
Same.
Same, my lord.
Okay. I will
Can
take
I
up.
please have order of this coordinate bench?
I'm setting it aside.
My lord, done.
If no record region is accorded,
No reason is recorded.
I am setting it aside.
Only, my lord.
Because no point filing an appeal
Yes.
without regions.
Yes, ma'am. Only stated,
And
report of
second-
the Lat Mandal rejected.
In item number 2, we have received the instruction, Lordship.
No, when order publicly made. And Mohindra Singh Gill cannot be supplemented. You, Mr. Doctor, please take out Mohindra Singh Gill citation and
My,
Govardhan Das Bhaji.
listen here.
It
In my,
cannot be. What is that? Last line? Old wine in a new bottle.
yes, my lord. My lord, in my case, my lord, it says the application is rejected by the circle officer as per the LM report, Lat
You
Mandal,
don't know. You don't know. Not furnished.
not furnished.
Okay.
Clause 6, Lordship. My lord, I should be informed, my lord, objection should be raised, Lordship, when it is in the law.
Clause
6, Lordship. Of the guidelines.
Hmm.
The ADC will verify the application can see LMs and CO's report. ADC can also raise objection on the application to the CO. My lord, after clause 3 is, Lordship, circle officer should verify.
those are internal things they
Yes,
do,
Lordship, yes.
but ultimately the region is to be provided to you.
Lordship, yes.
Okay. Item 220.
We have received the instruction in item 2, Lordship. Kindly approve. As per the notification dated 7/3/24. Lordship.
Mohindra Singh Gill to the. If you have justified reason, you reject showing reasons. The petitioners দুইটা প্রথম বেলাখিনি একে হব মানে বেলেগ হব পিছত একে হব ঠিক আছে the petitioners comma 3 in number have joined together to institute the present writ petition under Article 226 of the Constitution of India to assail an order dated 6/8 6/8 or 13/7 13-7.
It's 13-7, Your Worship.
13-7. To assail an order dated 6/8/2024, comma, preceded passed by the additional District Commissioner, Nagaon, within bracket the response number 3, comma, preceded by an order dated 13/7/2024. Full stop. By the order dated 6/8/2024. The response number 3 has rejected an application submitted by the petitioners to avail the notified public service, comma, quote unquote, composite land sale transfer, which was submitted on
Worship, it was submitted on.
29/5/2024 online.
Worship.
Oh. মই satisfied. খালি citation কেইটা দি দিব। Also, before the events leading to the rejection order, it is 6/8/2024, can be narrated, comma, in brief, comma, at first, full stop. Subpara. The petitioner number 1 and 2 no, it is stated that the petitioner number 1 and the petitioner number 2 are the joint owners,
Yes, Worship.
joint owners of a plot of land measuring 2 bighas, covered by DAG number 327 and patta number, KP patta number 1, comma, situate at village Boruavali, Moja Jarabari. Sorry, Moja. What Moja?
Moza is
Mr.
Lordship.
Ahmed
My Lord Zorabari, Lordship.
or Roha.
My Lord, Rohana Zorabari. That will be said, Lordship.
Should I activate yesterday's order? Every wrong translation, wrong information.
Roha, মানে
We'll put
circle
you-
office Roha. Lordship.
Then why you have written?
My Lord Roha Rivini Circle, Lordship.
Why you have written Roha Moja also? Moja Jorabari within bracket Roha.
Yes, my Lord,
For your mistake, I have to spend. Fine. Roha Revenue Circle, District Nagaon, subject plot.
very deep.
As there arose a necessity for the petition number 1 and the petition number 2 to sell the subject plot, comma, they entered into an agreement for sale of land with the petition number 3 on 29/5/2024.
24.
Full stop. Top para. The petition number 1 and the petition number 2 had thereafter, submitted an application before the respondent authorities to avail the notified public service, quote unquote, composite land sale transfer on 29/5/2024. And the said application was received and acknowledged. I'm sorry, and the receipt of the said application was acknowledged with application reference number page 66 NOC stroke 33 stroke 54523 stroke 2024. Post of the petitioners have stated that the application was submitted in the comprehensive citizen platform, Seva Setu. Post of the petitioners have further stated that while submitting the application, all the requisite documents were also submitted along with it. Post of to the knowledge of the petitioners, the respondent authorities had thereafter commenced inquiry for the purpose of deciding the application for the notified public service. Composite land sale transfer. When the petitioners, when the petitioners tracked their application in a comprehensive citizen portal, Seva Setu, the portal was showing the current status of their application on 13/7/2024 as quote unquote rejected. Post of. Subsequently, the portal, Seva Setu, the citizen platform, Seva Setu, showed the application processing history as under page 67. Table এখন আছে, quote করে দিব. This is 1710. Heard Mr. M.H. Hamitati, learned counsel for the petitioners, Z. Hajurika and Standing Counsel, Revenue and Disaster Management Department for the respondent number 1, Ms. S. Borua, and Ms. S. Borua, learned Junior Government Advocate Assam for the respondent number 2, 3, and 4. Post of. WPC number 1764. The petitioners, 7 in number, join together, to so and so, to assail by the impugn order, to assail an order
Page 52.
50.
52.
50. Assail an order dated 27/6/2024. Passed by the respondent number,
To
circle officer,
circular 3. Respondent 3. Last line, madam.
whereby post by the order dated 27/6/2024. The respondent number 3 has rejected an application submitted by the application or applications? Applications submitted by the petitioner
Online on 27/03/24.
to avail the notified public service composite so and so
Yes,
online
online.
on 27/3/2024.
Yes.
ইয়াতো এনেকে প্ৰচেছিং হিষ্ট্ৰীটো আছে হা চাই লওক লাষ্টত যিটো লিখিব লাগে narrated the event so and so. It is stated that the petitioners are owners and in possession of three plots of land, Roman 1, 3 plots of land measuring, Roman 1, 9 lessers, comma, covered by DAG number 265 and KP Patta number 410, semicolon, Roman 2. 11 lessers covered by DAG number 263 and KP Patta number 410 and 3. Para 3 does DAG number 2, measuring 1 katha covered by DAG number 266 and KP Patta number 411, comma, that is, comma, 2 kathas in total. Full stop. The plots of land situated at Revenue Village, Town Haibor, 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 Moja, Hodor Town, District, Nagaon, within the territorial limits of Sub-Register Office, Nagaon. Full stop.
Paragraph 5. Name.
As a necessity arose, agreement for sale of land on 20 with one prospective buyer on 24/8/2022. Registered deed of agreement for sale. It was registered.
Yes, ma'am.
And next,
2.
2. Okay. before the sub-register Nagaon.
No,
Wide register deed number 1696. Roman N, serial number 2304 on 24/8/2022. Post of Sapera. The petitioners have further stated that they applied for a no objection certificate from the Nagaon Municipal Board, and the Nagaon Municipal Board on 7/7/2023, and the Nagaon Municipal Board had issued a no objection certificate to the petitioners on 28/11/2023 under section 53 capital A within bracket 1 within bracket small Roman 1 of the Assam Municipal Act 1956 as amended. Post. When the petitions into online application the composites submitted applications, submitted applications before the respondent number 3 online for availing the so and so, and those applications were received by acknowledgement number
case 49.
case 49. এইকেইটা আছে 49, 50, 51 একদম টপতে আছে on 27/3/2024. Post. এই লাইনটো দুইটাৰে দিব while acknowledging the applications submitted for the notified service composite so and so, it was informed that the notified service would be provided within 45 days. And the petitioners could file an appeal if the service was not delivered within the said stipulated period. Posto. Check online and check through 27/6/2024.
Can my lord, one line may be
Huh.
added, my lord, along with the my lord application, the requisite fees have been.
But what did you the petitioners have stated that all the requisite documents, it was and the fees. দুইটাতে সেইটো লিখিব। Then similar parasito, when the petitioners tried to obtain the status of their application in the citizen portal Seva Setu, they came to learn that on 27/6/2000, the application was submitted by the petitioners were rejected by the respondent number 3 on 27/6/2024. And the citizen portal so and so Seva Setu reflected as follows. Page 52, the application is rejected by cycle officer within bracket rejected as per LM report bracket close. Page 52. Then processing history, application processing history, page 53. Heard Mr. N.J. Doctor. Learned counsel for the petitioners. Ms. Z. Hajorika, Learned Standing Counsel Revenue and Disaster Management Department for respondent number 1. And Ms. S. Borua, Learned Junior Government Program for respondent number 2 and 3. Post note. The learned counsel, for sorry, Mr. M.H. Chame, Baki to Doctor. Mr. So learned counsel for the petition has submitted that the service, composite land sale transfer, quote unquote, has been declared to be a notified public service under the Assam Right to Public Services Act, 2012, in all the districts within bracket 2012, wide a notification bearing number so and so dated 11/11/2022.
11/11/2020.
Full stop. As per the said notification, commander designated public servant within bracket DPS is the deputy commissioner within bracket presently district commissioner. Stroke any or any one to be nominated by the district commissioner. Full stop. As per the said notification, and the citizen charter annexed thereto as Annexure 1, comma, the stipulated time limit for providing the service is 45 working days. Full stop. Referring to the order of rejection passed by the designated public servant, annexed as so and so to the petition. Mr. So and so has submitted that the impugn order is a non-speaking and cryptic one. Full stop. Considering the fact that a rejection order passed by a designated public servant under the provisions of the Assam Right to Public Services Act is an appellate order, it casts obligation on the designated public servant to record the regions. Full stop. Non-recording of the regions has made the rejection order an arbitrary one, and the same is liable to be set aside. Full stop. The learned counsel for the petitioner has referred to the provisions of section
21 capital A of the registration.
21 capital A of the Registration Act, as amended for the state of Assam.
Yeah, Assam amendment within bracket Assam
We'll do that.
2009.
এখানে bold করে হোক, change করে দিন। And section 7 within bracket 2 of the Assam Right to Public Services Act 2012 as amended. Full stop. Para the Learned Counsel for the official respondents have submitted that since the order of rejection is an appealable one, comma, the petitioner, instead of approaching the this court by writ petition, ought to have approached the appellate authority by preferring an appeal. Yes? Anything else? Okay. NJ Dr. Likhibo. Ms. Borua has submitted that the application of the petitioner was rejected in view of a notification dated 7/3/2024 of the Revenue and Disaster Management within bracket Registration Department, Government of Assam. Full stop. Para. The Assam Right to Public Common. I have really considered the submissions of the Learned Counsel for the parties, and I have also gone through the materials brought on record by the petitioners. Full stop. I've also gone through the provisions of the Assam Right to Public Services Act 2012 as amended and the Registration Act what is it? Amended.
Registration within bracket
Uh,
Assam Amendment Act
Registration Act 1908.
2009, madam.
No, sorry.
The amendment.
The registration within bracket Assam Amendment, bracket close, Act 2009. Section 21A. Section 21A
Yes, capital. A.
of the science. First one. Para. The Assam Right to Public Services Act, comma, 2012. When you make it the ARTPS Act, for short, has been enacted by the Assam Legislative Assembly in order to provide delivery of notified public services to the people of the state of Assam within the stipulated time period and for matters connected therewith and incidental thereto. Full stop. The Act received the assent of the Governor of Assam on 27/4/2012 and was notified by a notification dated 2/5/2012. Full stop. The AR সেইটো লিখিব act বুলি কৈ আছো মই the act has been published in the Assam Gazette in issue number 194 dated 2/5/2012 post of para as per section 2H comma quote unquote right to public service unquote means the right to obtain the notified service under the act from time to time within the stipulated time limit as described under section 5. Stop. Section 5 of the act has laid down that every eligible person shall have the right to obtain the services in accordance with the act within the time-bound period as notified under section 4. Full stop. Para. Null. It is the liability of the designated government servant to deliver services, comma, under section 6 of the act, comma, within the stipulated period. Full stop. The stipulated time period, comma, as per section 7(1), comma, starts from the date when the application for obtaining the required notified service is submitted to the designated public servant or to a person subordinate to him authorized to receive the application. Full stop. It is further mentioned that such applications shall be duly acknowledged. Full stop. Subpara. As per section 7 within bracket 2, comma, the designated public servant on receipt of an application under subsection 1 shall, comma, within the stipulated time limit, comma, provide the notified service or reject the application. And in case of rejection of application, comma, he shall record the reasons in writing and communicate to the person making the application. Colon, yes, tinta ase. 1, 2, 3. 1, Roman 1, the reasons for such rejection. 2, the period within which an appeal against such rejection may be preferred. Semicolon. And 3, the particulars of the appellate authority. Para. Subsection 1, section 8 of the Act has provided for appeals. First, as per subsection 1 or 1 of section 8, any person, comma, whose application is rejected under subsection 2 of section 7 or who has been provided the notified public service, no, who has not been provided the notified service within the stipulated time limit, comma, may file an appeal to the appellate authority within 30 days from the date of rejection of application or the expiry of the stipulated time limit. The proviso to subsection 1 of section 8 as first provided that the appellate authority may admit the appeal after the expiry of the period of 30 days, but in no case beyond 60 days from the date of rejection of application or the expiry of the stipulated time limit for delivery of that particular notified service, if he is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time. Full stop. The second proviso to subsection 1 of section 8 has provided further that in case of rejection of an application for a notified service for which any other law for the timing in force prescribes remedy, the applicant shall follow the process under such law for the timing in force. First para. Do we have that registration? Okay. It may be, okay. It may be apposite to, it may also be apposite to refer to the relevant provisions of the Registration Act. First of, okay. Yeah, yeah, 6.
Yes, people on the.
এই রেজিস্ট্রেশন এখন এখন আমার আসলে আমার নাই আমার নাই এখন আমার একটু yeah, 6, 7. Eight and 9. Both the provisions, both the provisions of section 7(2) of the Assam Right to Public Services Act, 2012, as amended, and section 21A of the registration within bracket Assam Amendment. No, the Registration Act 1908 as amended by the registration within bracket Assam Amendment bracket close Act 2009. have cast an obligation on the designated public servant to record regions in the event he decides to reject an application for a notified public service. Full stop. Para. In the case in hand, in the case in hand, comma, the application submitted by the petitioners for the notified public service composite so and so on so and so has been rejected by the respondent number 3, citing the following, purportedly citing the following reason. Twitter. Son. NJ Doctor 2. Quote unquote, the application is rejected by cycle officer within bracket, rejected as per LM report. The application is rejected by ADC within bracket, reject as sufficient documents not submitted. Right? By the notification dated 11/11/2022, the revenue and the state government has the notification dated 11/11/2022 is on the subject, which has quote unquote. The notification has been issued with a view to provide the delivery of public service to eligible citizens within the stipulated time limit and states as under service name. Service name, pencil designated service name. So you have provided all these documents?
Yes, sir.
Okay, documents
In that notification,
Huh.
my lord. And
all
second,
these documents.
yes, my lord, in the notification, my lord,
Huh.
only I am pointing one, my lord. 1, 2, my lord, 2, my lord. The submitted application is automatically forwarded to the concerned land mandal, will verify the land details along with the supporting documents. On being satisfied, LM verifies the scheduled land physically and submits the physical verification. In the instant case that
The notification has further provided the procedural steps to be followed by the authorities involved in providing the notified public service in the notification has further mentioned about the user charges. Full stop. As per the citizen charter annexed to the notification is annexer 1, comma, for the notified public service, quote unquote, composite land sale transfer, comma, the deputy commissioner or an authority to be nominated by the deputy commissioner is the designated public servant, and the stipulated time limit for providing the service is mentioned as 45 days. Full stop. In the citizen charter, comma, the commissioner of divisions has been mentioned as the appellate authority. Full stop. It is madam, it is পাই যাম এইখন পঞ্চায়তখন থৈ দিব মোৰ টেবুলত থৈ দিব পঞ্চায়তৰ মিক্স হৈ যাব নহ'লে গোটেইখন এইখনেই You gave some document, no? That abolition. Out now, fellow. It is submitted by MS Hazurika, learned sending us revenue department that the office of the commissioners of divisions has been abolished in the meantime, and presently, comma, by another notification dated 16/11/2023. The Revenue and Disaster Management Department has been made the appellate authority state government in the General Administration Department, huh? Para. On perusal of the impugn order of rejection, comma, it is evidently clear that the impugn order is not in conformity with Section 7 within bracket 2 of the Assam Right to Public Services Act, 2012, and Section 21 of so and so, 21A. First off, a speaking order is one which expressly states the reasons for the decision. Full stop. In other words, a speaking order speaks for itself by assigning the reasons behind the conclusion. Full stop. If an order is passed without giving a reason by the concerned authority, more particularly when the authority is a statutory authority, then the order is a non-speaking one. So some non-speaking order is one which does not provide a clear reason for its decision. Full stop. An authority exercising statutory power must record reasons for its decision. Unless such obligation is not expressly or impliedly dispensed with. Full stop. It is implicit in the principles of natural justice and fair play that an authority which has been vested with the power to decide a matter should record reasons as it is part of fair procedure, more particularly, when the decision is likely to affect the person concerned. Full stop. In the case in hand, the right of the applicant is also traceable to Article 300, capital A of the Constitution. Full stop. Though the right to property enshrined in Article 300A of the Constitution is not a fundamental right, but, it is still a constitutional and human right. Full stop. Recording of region is also primarily suggestive of conscious application of mind on the part of the authority. Post of the obligation to record regions is a possible check against arbitrary action on the part of the authority invested with the statutory power to take a decision which is likely to affect the right of the person concerned. Full stop. When the statute itself contains a prescription to record regions in the decision, absence of regions in the decision falls short of the prescription and would be in violation of the prescription and thus, illegal. Full stop. where a submission has been it has been canvassed on behalf of the official respondents that the petitioner has approached this court by filing the instant writ petition in order to invoking the extraordinary remedy instead of availing and the alternative statutory remedy, which is adequate. Also, it is no longer it is settled law that in the even if there is an alternative which is adequate and efficacious, even if there even in presence of an alternative efficacious and statutory remedy of appeal, a writ petition under 226 of the Constitution of India is maintainable on the grounds 1, 2, 3, 4. In the case in hand, the petitioners have alleged a violation of the principle of natural justice as the designated public servant, while deciding their application for the notified service, public service, has violated the principles of natural justice. Composite shell transfer. Yes, it is true that in, the petitioner has not availed the alternate remedy of appeal after the order of rejection. Posto. In the facts on the basis of the facts, in view of the facts, situation obtained in the case, this court is a considered view that when the extent of vulnerability of the order of rejection on the touchstone of not meeting the statutory prescription of recording regions is considered against the point canvassed by the official respondents that the petitioner regarding non-filing of appeal comma, it is the vulnerability of the order of cancel, order of rejection of the application, which far outweighs the ground or outweighs the region or outweighs the other region regarding the petitioners not filing, not approaching the appellate forum. Full stop. Recording only. Recording only. Apa lagi, Bos? Apa lagi, Bos? Thus, comma, from every standpoint, comma, the impugn order of rejection dated so and so is not a speaking order as such. The impugn order dated so and so is found to be one which is passed without any application of mine for the aforestated regions, comma, the impugn order dated so and so, rejection dated so and so cannot stand the scrutiny of law and is liable to be set aside. Full stop. Para. With the setting aside of the rejection order, comma, the as the order of so and so, order of rejection it is so and so has been set aside. It is now the obligation of the designated public servant to proceed to consider the application submitted by the petitioners for the notified public service composite so and so, strictly in compliance of the provisions of Section 7(2) of the Right to Public Services Act and Section 21A of the so and so, and the notification dated 11/11/2022, and pass a speaking and region order within a period of 45 days then. 45 days from the date of submission of a copy of this order by the petitioner at the office of the designated public servant.
I'm obliged.
We'll make some correction regarding
Fine.
the region wanted to show by
Fine.
on the basis of Mohindra Singh Gill.
Yes.
Because that judgment is a big one. It is difficult to find out. Both are with the observations made above and the direction with the direct observation made and direction given above, comma, the writ petition stands allowed to the extent indicated above. There shall, however, be no order as to cost.
Obliged.
Oh, ৰ'বা, মহেন্দ্ৰ সিং গিলটো বেছত ওলাই ল'ব লাগে হা অ আপনি আছে নেকি আমাৰ আজি কোনখন কৰিবা ইয়াতে আছে নেকি ক'ত কৰিবা কাগজখন ক'ত কৰিবা অ অ মাতি
List, item number 16.
Met Pili Lawson. Yesterday the matter was listed, Lawson.
yes notice has already been issued actually listing base 23 and 24 and 25
Lordship.
these are the thing
Lordship.
okay we'll dispose of them
Only I get paid. If we are paying for similar order, page 41, Lordship. Page 38.
38
Only Lordship, I pray that last paragraph may be modified.
38
Start from 38.
huh
Paragraph 11, page 48, 43.
paragraph
Paragraph 11.
11 11
University directed the authority to communicate the views. Lordship, probably under the GST, this is self-assessment. The filing of the return, they have to determine the tax and deposit.
which one you want correction
Paragraph 11. Lordship.
paragraph 11 impunity have set aside director to approach the concerned group within a period of 1 month for seeking revocation no this I think I have modified the other part the recent one I have modified this paragraph 11 that day I passed the order that
Yes, Lordship.
he has the option of either paying all the dues or submit a reply.
Yes.
And if the reply file, authority will consider according to law. If it pays the dues, all the dues, penalty,
This to be determined by him.
him,
Yes.
him. So if he is that, please come to, I have, please come to that part where is rule
23.
20.
Three.
A recent class, na? 1 minute. Page 41, you please see. Rule 22, page 41. I have given him two options. See rule 4. Rule 4.
Rule 4 of Lordship.
Rule 4 of Rule 20, sub-rule 4 of Rule 22.
So this is cancellation of registration.
Oh, this,
Where the reply furnished under subsection sub-rule 2 or in response to the notice issued under section 2A is found to be satisfactory, the proper officer shall drop the proceeding and
if satisfactory, he will drop. If not satisfactory, pass an order cancellation, proviso,
Yes.
proviso.
where the person is not replying to the notice served or sub-rule 1 for contravention of the provision contained in clause B or clause C or subsection 2 or section 29, furnish all the pending returns and makes full payment of the tax dues along with the applicable interest, late fee. The proper officer shall drop the proceeding.
So three things.
Yes.
That instead of filing reply, he can pay all the dues, penalty, so and so. Then the proper official drop. And second option, he has the option of filing and reply. Then he will invite the risk. If it is satisfactory, it is dropped. If it is unsatisfactory, his cancellation registration again goes. Thereafter no remedy. He runs the risk.
Paragraph 11.
I have modified.
Yes.
I have modified.
Then not.
Please find out. I think I have modified.
Then not.
With time, person becomes wiser.
Not.
Oh, একদম recent to. একদম recent to them. একদম recent to the কালি দিছিল।
In case of Ravi Misra case. Not.
Please find out. This has been modified.
Then not.
Please have a look. You can suggest. Now he can go pay all the fees, penalties and all. Paragraph 12.
Paragraph 27.
Last but one. Last but one.
27. Yes, thank you.
So here's the option.
Yes, sir.
Go to the proper officer, deposit all the penalties, everything up to date.
Yes, sir.
Then drop. Cancellation is gone.
Sure.
There will be no cancellation. And he can
Submit,
submit reply. If it is satisfactory, drop. If it is unsatisfactory, then again cancellation. Then he will suffer. So ultimately he has to pay the money, penalty, everything. We'll decide.
Not.
We'll pass the order
Not.
in this line.
Not.
Yes. Yes, Mr. Do you have the instruction?
So I'm extremely sorry.
Items 18 to 49.
I don't know the English one. There are two separate notification issued. One under subsection 1, section 31, and one for reorganization of development blocks.
Just see. Gazetted. Gazetted.
Separate notification for his district. There is a ZPC notification sheet also there.
Why you have not placed it before? Before I've been hearing all this.
We have prepared the case as per their things.
No, but alternative, you are resorting to 5-1 and 5-2. 5-2. But to find out 5-2, it is not matching. Yes, what do you say? These are all gazetted. Have you seen?
My friend has allowed me to see this one.
Yes, because it is gazetted, it is held to be law. It is in public domain. That cannot be an excuse for any citizen.
I understand, Mr. P.
This I have been put into a rigmarole.
These has only come out because of your lordship,
Yes.
and not from either of the.
I have been putting it to Mr. Kumar time and again, whether there was any notification under section 31. Last 1 month, I don't know, I don't see the portal. Let us see. All these are gazetted. 20.
I have submitted.
Just as a test case, we are not,
Yes, yes.
we'll have the presumption under section 1, what? 4.
Earlier.
Now it will be separate, but the similar provision must be there. Ratio is same. So evidence act. Evidence act 114. There is always a presumption. Is it not? 115, sorry.
Can dispute of the 57 of the judicial notice, because it is a gazette notice.
Yes,
Judicial notice can.
yes, sure. For 114, I'm sorry, correct. I was correct.
57.
And the court may presume. Court may presume. The judicial and official acts have been regularly performed. This is one. And
57, I think.
57 perhaps, yes.
Judicial.
Facts judicially noticeable need not be proved. Facts of which court must take judicial notice, section 57. All laws in force in the territory of India, all public acts.
Gazette notification. Public domain.
Perhaps gazette is there. And what is oh,
Corresponding.
Ah.
9 of. Such a corresponding to 1 month.
and this is in the category of public documents,
75, 74, 75.
74, 75. So as per this notification, issued under subsection 1 of section 31, Anchalik Panchayat has been declared. Name of the Gram Panchayat has been declared.
Yes, ma'am.
What do you say about this? On 21st, 19 October. 19 October.
In spite of repeated order by your lordship to file affidavit.
No, I have
counter-
not passed any order. I put the query.
No, my lord, on other day.
Finally, day before yesterday, I passed the order.
No, not in this regard. As a whole, the affidavit to be filed on the repeated orders, they have said that it is filed, your lordship has ordered that it may be tagged also, but not filed as of now, my lord. So not filing of a counter affidavit amounts to the admittal of my case, my lord. And they have not filed, counter. I do not believe them, my lord. Whatever they are filing, I do not believe the verification. My lord.
And where is Mr. R.C. Paul? Can you call R.C. Paul? They in issue it is a writ petition. R.C. Paul. Okay. Lekhak. Anything to say on this?
My lord, only one thing, my lord, last evening, my lord, the notification is published regarding the Panchayat election, notifying the same, my lord. Only this month I want to bring your lordship notice, my lord.
Hello. Mr. Dubey has, at 10:30 has brought it to the notice by placing that.
Yes.
Post. Third, Mr. K. Kaur. Right. Additional advocate in Assam. And senior standing counsel, Panchayat and Rural Development Department for the state respondents, along with Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission. Full stop. Mr. Kaur, on behalf of the Learned Advocate General Assam, has placed a set of notifications Gazette notifications. A set of notifications dated 19/10/2024 and issued under subsection 1 of section 31 and dated 21/10/2024, issued under subsection 1 of section 65 of the Assam Panchayat Act, respectively. Full stop. Mr. Dubey has placed a notification dated since regarding issued by the Assam State Election Commission regarding declaration of election. Full stop. The notifications relating to the districts of Kachar and Hailakandi, Karimganj are kept as part of the case records. Poster. Mr. Arsipal is available now. Because I have seen an office note in his case. He deposited court fee for one person, filed by a petitioner, not more than one. And despite repeated information by the registry, he refused to deposit. He refused to deposit the court fee, saying that same cause of action, but High Court rule says differently. Pay separately. So this is akin to Order 7. Rule 11. Though it is not illegality, it is an irregularity, but if it is not cured, then it is illegality. I think that is the proposition. And in the office notes, it is recorded that despite information to the Learned Counsel, he refused to deposit the deficient court fee on the ground that one petitioner's court fee will suffice. That is recorded. So it has become curable irregularity has become illegality. That is why I want to put him on notice. Oh, is in office notes.
Can reflect in the order and granting some time so that he can.
No, it was given. It was given. Till then, it was irregularity, curable. At least have a look, both sides. So I may not entertain his writ petition on that ground itself.
Our perusal may not suffice.
But no, at least I am seeking guidance from you, whether that my tentative view is correct.
They can join for the same cause of action, but separate
Yes.
court fee has to be paid.
Yes. Official acts presumed to be correct. Show it to Mr. Kumar and Dubey. Please read out.
Order dated 6/1/24. In this writ petition, there are 5 numbers of petitioner, and accordingly filing section has insisted for a court fee of rupees 258.80 as per Rule 1 of Chapter 5A of the Guwahati High Court rules. But learned counsel for the petitioner is of the opinion that court fee is required to be paid only for one petition. In view
So-
of above, the registry leaves the matter to the honorable court to decide the issue.
So court will decide. What do you say, Mr. Dubey? On it? Whether it is to be entertained or not to be entertained?
Grant one more opportunity.
No, we are closing it today.
Not that your lordship is closing, but if he can.
If he can come,
The last opportunity.
Mr. No opportunity. This was recorded on 6/1/2024. No, 6/1/2025 by the deputy registrar. Deputy registrar. Mr. P.K. Roy Chaudhary. The respondents are represented by Mr. P.K. Roy Chaudhary with Mr. H.I. Chaudhary, and Mr. A.K. Talukdar. Anybody from the respondent side? No, stop. The hearing is concluded. Judgment is in. You can't say for native.
Obliging.
Mr. Kaur, had it been placed before it, then things could have been easier for the court. You please.
Sorry, your lordship, but I was
No,
Depending
when
case-
you take a brief, you should be aware of all the things which developed in the interregnum.
State has more responsibility than a state. The state will-
State has to be fair before the court. I've been repeatedly telling the state has to be fair. If the procedure adopted appears to be fair, then the things is different. But there are missing links in section 5(2) notification.
Your lordship, we have relied on the GP notification. Sorry.
Yes.
My matter 42, whether it's segregated or not. Last occasion, lordship,
We are closing it now. No, what was your prayer?
where,
Very
my lord,
No, please tell me without opening the brief.
my lord, they distributed the voters, my lord, among the wards, my lord. Some wards, they put only 200 and some ward is 1200.
We have already concluded. We can't help it now.
For admission, items 3 and 4.
Particular, no?
Earlier lordship has order, my lord, in this matter, my lord.
No, when the opportunity was granted, one should avail it.
But
This is not for the court.
I was there in every occasion, my lord, but
Look,
I-
Mr. Atia, it is very difficult for the court.
The similar order, my lord, already passed your lordship earlier, my lord.
We have already
The
reserved
similar
now.
issue, my lord.
We have already reserved.
My lord, can we see the order lordship pass?
I have not passed any order in your case. So whoever has
not in
applied
this
during
case.
the hearing that their case is different, I have allowed them to
They took
go
time,
out.
took time for submission of.
End of the matter. Yes, next.
May I please, Lordship? So this is the GST bank account attachment matter, Lordship.
Regarding item number 3, we filed the affidavit, it has been signed, my lord. Because of some, my lord, illegible, my lord, annexures have been provided to us.
Now perhaps that affidavit might not be required, Lordship, because it is applicable for 1 year. They have not been able to file affidavit. It ends day after tomorrow.
So whatever be, my lord, and then, but there is a subsequent development also. The entire fee of the repetition is this, my lord, it has not been freezed under section, my lord, 83 of the GST. State GST. Now, my lord, an order my lord, modifying or freezing, my lord, has been issued. Now we have to challenge that. part.
No,
I-
where is
I-
that order?
Yes, I will furnish that. It will be there in affidavit.
No, it
No,
will be
first
there,
tell me,
Lordship.
Mr. Gogoi.
Hello.
After having a cursory look
Roughly.
to section 83,
Lordship.
GST.
Lordship may take the latest book if I may furnish.
Now, I have one. For the registry to obtain latest book, it is very difficult. Everything,
It always keeps
there is
changing.
a process always.
Every year it changes.
It changes for tax matters, it is very difficult.
Lordship. Section
Now,
83,
one more, 83.
83, Lordship. There are certain limbs of the section, Lordship.
83.
Provisional attachment to protect revenue.
No, just one more, to have an idea.
Lordship.
83(1), where after initiation of any proceeding,
That is the first limb.
first limb,
Okay.
just indicate from your documents.
Yes, Lordship.
It will be, my lord,
That attachment, because this is what follows is provisional attachment.
Lordship.
so far as, my lord, so far as the present case is concerned, my lord, it was freezed, not attached initially.
What is the difference between attach and freeze then?
My lord, freezing was made, my lord, in order to protect the revenue, my lord, because preliminary amount where, my lord, particular amount where, my lord, withdrawn or refunded to the petitioner. Now, my lord, subsequent to that, my lord, the process was initiated, my lord.
Subsequent. Not before that,
And,
Lordship.
my lord, we have stated in the affidavit in the next item, my lord.
Where is the power to attach or debit freeze? Where is the power? Any other provision?
Freezing only, my lord, the debit part has been freezed. Credit part is there.
It is a property.
So
It is
that
a
part-
property.
That part I am aware, but Lordship will see, my lord, fraudulently when, my lord, a person does something, my lord, then it vicious everything, my lord, in order to protect it, my lord, we have checked the, my lord, records. There is not a single, my lord, input tax credit due to the petitioner.
There is not
despite
even
that, my
that
lord-
finding of fraudulently, Lordship.
Despite that, my lord, in connivance with some of our officers, that amount has been, my lord, refunded to the petitioner. Where, my lord, in invading cases. where-
Affidavit has been received from respondent number 5.
Everyone has filed affidavit, Lordship.
In item number
Both items, Lordship.
6431.
Yes.
Now, what is the case?
Lordship has gone through section 83 that after the initiation of a
That is
proceeding.
what I am trying to find out.
Yes, Lordship.
I know only the basic minimum thing.
Yeah, I am
And when
pointing
act is to be done in a particular manner,
It
that
has to be done.
must be done in that
in
particular
that
manner.
particular-
Every other manner is illegal.
Lordship. Now, Lordship will again.
So
quote you-
after initiation, so you show me any dictionary difference between it is a provisional attachment.
No, not a provisional.
No,
under section 83.
sections 83 says
Lordship.
it is provisional
Attachment.
attachment.
Lordship.
Any property. Now, Topon Yogi says bank account is a property and it is under Article 300A. No doubt about it. Now, what is the difference between debit freeze and attachment on which your argument is based? One broad aspect is that if we assume debit freeze and attachment is different, that debars the account holder to withdraw anything.
Lordship.
The other element you may argue that he may debit credit there. Then that is to his detriment because he cannot take out that.
Lordship.
But that was.
I think that will be your argument. So what difference does it make? Because he is debarred
In my
by the
But here.
debit freeze order.
Yeah, in fact, my lord, here the process was initiated through a show cause in September 24, not in April.
Right. And where is when it was debit freezed?
April 24.
No, that's why I'm saying, my lord. Lordship will say 83. It says, my lord, after initiation of a proceeding, then only it can be, my lord, freezed or, my lord, say whatever, attachment and all. It will go by strictly by the, my lord, provision of 83. Here, my lord, the proceeding has been initiated sometimes in September in the item number 3 by a show cause on this particular point. And my lord, this particular subsequent modification has been done, my lord, 13/3/25. That's what I'm saying, my lord, that attachment has now been under 83. It has been done on 13.
Then why this man has passed the order?
No, what they have done subsequently is not on record.
So that's why I filed my affidavit, my lord.
It is
No,
not
but
required anymore.
It is palpable from your from the document annexed by the bank.
Lordship.
At least we have this before us,
The affidavit.
their affidavit.
Page 52.
John Senna or that,
Yes.
if it is
They first,
SE, then it would have been the WW factor, John Senna. Yes,
they first
he
issued a
has-
letter, Lordship.
he has done this on 2/4/2024.
Yes, sir.
Now tell me, what is the difference between any laid down law that debit freeze? He has passed an order
My lord.
and followed by another order
Lordship.
Lordship will-
in excess. Let us see 150 Assam Goods and Services Act.
Lordship.
Oh, that is
Same.
regarding
He can-
balance.
he
That
call
can
for
be done.
information,
But
Lordship.
what about this page 58?
This is attachment, Lordship.
Lordship will see, my lord, the subsequent communication.
No, we are on the 83.
Lordship.
Yes.
We are on the 83.
Now, under 83, it has been assessed again, my lord. Lordship
If
will
the,
see
if by, no,
That freezing will
we are
be-
also concerned with the thing that it was filed in the year 2020. Right,
my lord.
on 2nd December 2020. Right, there is no state affidavit and validity of any attachment order is up to 1 year.
Lordship.
Then we are on the verge of that if we count it from 2/4/2024.
Lordship.
Now, if there is difference legally in legal terminology between debit freeze and attachment of a bank account, then yes,
Lordship, I can
otherwise,
show it is the same.
after initiation, you said we have initiated in September, but this is in April.
No, that's why, my lord, it is not under 83. The April order was not under 83. There is a consistent stand, my lord, in the affidavit that we have filed.
Okay, we'll decide then.
Lordship, I can show
That's
to
why-
your
that's why I'm
Lordship
saying.
that debit freeze and attachment are one and the same thing under their acts and rules. I can show to your Lordship.
Okay. Okay, then let us hear.
But so far item 3, my lord, I will file one, let me file the. affidavit,
Item
let me
4
see
can
on
be
the contract.
disposed of.
Yes, 4 Lordship will see, my.
And if it is same, then perhaps no further requirement. Your Lordship takes up rule 159 and Form DRC 22, it will be clear that debit freeze and attachment are one and the same thing.
What is the corresponding rule of 83?
159, Lordship. Rule 159, CGST rules.
Which one is the latest? Let me compare your book with it. Because sometimes it is,
It keeps changing every year, Lordship. Rule 159 is the relevant rule, Lordship.
1 minute, 159.
9. Rule 1. Sub rule 1.
159.
It basically says, Lordship, that there is only one manner in which it can be attached by issuing one form GST DRC 22. 159, 1, Lordship.
Decides to attach.
The section 83 says, 83(2) says. Regarding that 1 year period. Says every such provisional attachment shall cease to have effect after the expiry of a period of 1 year from the date of the order made under subsection 1.
Because your order, this 33 order, see your content of the order, he understands. He understands it.
So far as
What is there?
83 that 4th line MAI 80424001.
When he says, I have the honor to inform you, various letters issued under reference number so and so from 1/4/2024. He is quite aware. To 5/4/2024. These two, which has been appended to the affidavit of the
Yes, going by the second para, it seems
requesting the freezing of certain bank account. You have to show that whether freezing does not amount to attachment. Otherwise, it is an admitted position.
So, yes, of course, after this letter, yes, it will be same because we have our own motion volition, we have made this.
So if you can distinguish this legally, that freezing is different from
Yes. But we have only tried. to say that-
admittedly, it is. That does not mean that I am not saying law that may permit you again. But question is legality. About
Our instruction is very clear, my lord, so far as the April order. is
any
concerned.
banking dictionary is available.
Lordship,
Any banking dictionary is available. Banking
banking?
dictionary.
No, it is not available.
Huh?
No, Lordship, DRC 22 itself says no debit shall be allowed to be made from the said account.
1 minute.
So what
Let me
difference does it
read
make?
first. Let me read.
From DRC 22. 463.
Assam. এখন আসাম নেই। And what are the proceedings that indicated in section 83?
Yes. Lordship, those proceedings are scrutiny, show cause,
Chapter Roman
12, 14 and 15.
Roman 12.
Audit, scrutiny,
1
assessment.
minute.
Chapter number 12, 14 and minus 15.
No, that includes what are the provisions? Section. Chapter
Chapter, the first one is 12. It is regarding
Yeah.
assessment.
Chapter 12. The index is not clear. Chapter 12.
Lordship.
Chapter 12, advanced ruling.
It starts from section 59, Lordship.
No,
Chapter
that's
12.
section 83. Section 83, please.
Yes, I have gone through it.
Where after initiation of any proceeding under chapter Roman 12.
Roman
right.
12, section.
Roman 12 is,
59, it starts 59 to 60.
huh?
It starts from section 59, Lordship, chapter 12,
Chapter 12.
Lordship.
Huh?
What is the contents number to be clear?
Chapter 12. One. Chapter 12, yes, assessment, 59 to 64.
It is assessment.
Right.
But-
Chapter 14,
Inspection,
inspection, search, seizure, arrest, 67 to 72.
Lordship.
Or chapter 15,
15 is that 73 and 74.
73
Lordship.
to up to 84.
Lordship.
The question is whether any of the proceedings
Yes.
under these chapters
Yes.
Very
were
good.
initiated prior to David Freeze on 1/4/2020.
Prior to no, that's why I'm saying, well, it was not under 83.
Now it has been clarified by this letter that it will be 83.
We'll take note of this. We'll take note of this. If you, unless you come up with
Yes.
difference between attachment of a bank account or a debit freeze, because both diverse withdrawal of money.
Lordship.
And on the other, your argument could be that debit freeze does not permit, does not debar credit. Then what prejudice
Is caused.
is caused? 100% prejudice.
But
If he goes on crediting amounts, all will debit freezed. It will not come out. It is like a death chamber until it is.
They have to resort to this mallet exercise just to save the revenue. Moment we issue the notice and thereafter if we go for mallet freezing of the account.
Because
it will
there
be
has
zero-
to be,
zero
Mr.
balance.
There has to be Mr. Gogoi.
It will be zero balance.
Uh,
They will withdraw every
No,
penny.
that is different thing, but that one thing is that the commissioner has to take a conscious decision. He could have taken the conscious decision on 1/4/2024 itself.
Yes, so far that might not be-
It is not that it is cart before the horse. Horse should have been before the cart. Then on 13/3, after about 1 year, the commissioner decides to take conscious decision.
Yes, system commission at the district level.
Whatever, that this letter, deputy commissioner in charge, whether he is delegated with that power,
Well, yes, they are the authority, mallet, who will.
no, it is commissioner. So whether he is permitted under delegation to exercise the power of commissioner, because he himself is in charge deputy commissioner.
Mallet, he can, mallet, because mallet, all these officers are appointed only to assist the commissioner. So
Right.
perhaps they can accept.
No, that is why you refer to the provision. I'll accept. I'll accept because that day CGST has produced a document that under this provision, these powers are being delegated to a joint commissioner or commission. There has to be delegation.
Mallet,
Now, show me, because I am not very much accustomed with the provisions of the Act and the rules. So you might be aware that under this section, the commissioner can delegate the power to any of his subordinate officer. And all the powers may not be, right? And some of the powers, and if this is to be delegated, then this is to be delegated by notification. Let us see delegation of power. Let us understand.
Section 5 perhaps, Lordship.
Maybe because that day, Mr. Kyle has produced one.
It should be section 5(3), Lordship.
5(3). Let us see. Powers of officer. Subject to such condition and limitations as a board may impose, an officer, Central Tax may exercise the powers and discharge the duties conferred or imposed on him under this Act. An officer of Central Tax may exercise the powers Commissioners, 3.
Lordship.
Commissioner may, subject to such conditions and limitations as may be specified in this behalf by him, delegate his powers to any other officer who is subordinate to him. Right? So it is very specific commissioner rule. So here below him may be joint commissioner, below him may be deputy commissioner,
So many.
below him may be assistant commissioner. Do you have this Radha or Justice Chandrachud judgment?
I have.
Because he expressed urgency and at that point of time. We can take note of your affidavit.
Yes, Lordship, it is already there.
But affidavit is in the next page. Then see one of the affidavit.
If your Lordship takes up both the cases together, those are similar cases with the same letter, both the accounts.
Because
three
you
accounts.
said both the cases should be taken together
I understand, madam. I was supposed to file the affidavit in three also.
on Tuesday then.
It can be disposed of.
On Tuesday, at least on this point, madam, if I can furnish some.
Lordship, once it is fixed on Tuesday, it runs till next month
Then it is.
because of their inaction.
Tuesday. You make sure that your affidavit comes on record.
Lordship, I have failed to point out that Form GST DRC 22, by which the bank accounts has been prescribed to be attached, it says no debit shall be allowed in the bank account, the prescribed form. So there is no difference between an attachment and a debit fees.
Like in the item 4, madam, 22, madam, form 22 attachment has been made. Now, as per the rules.
Form 22 DRC.
Yes.
Now made. Now show me any evidence of initiation of any proceeding under chapter 12, 14 or 15. Any document.
It was in June
Yes, it was
2024.
there, madam. In June 24, madam. in
It
the
was
item
initiated.
4, It was there.
On
Okay.
the date of first attachment, it was not there. In June 24, they issued a show cause notice, which is also the subject matter of challenge in this writ petition. The reason being, in May 2024, I have made a voluntary payment which has not been considered in the show cause notice. So I pray that the attachment should go, the show cause notice should go.
Okay, dear Mr. Gogoi, then in this 6431 affidavit will be on record, okay, on Tuesday. Hired Mr. D. Sharaf, learned counsel for the petitioners in both the writ petitions, and Mr. B. Gogoi. Oh, congratulations for being the additional advocate general. So we'll record that, that additional advocate general. And also record this finance taxation. Okay. And Standing Council Finance and Taxation Department for respond number 1 to 4 in WBC number 6431 2024, and for the respond number 1 to 5 in WBC number 5774 2024. And Mr. P. Das, Council for the respond number 5 in WBC number 6431 2024, and 6, respond of 6 in WBC number 5774 2024. Full stop. Mr. Gogoi has submitted that the though the affidavit, counter affidavit
Yes, sir.
on behalf of the Finance and Taxation Department in WPC number 6431 2024 has been filed, but the same could not be has not been accepted due to certain deficiencies.
No, it's not been filed, madam. I'm waiting for that, madam, to collect some, madam.
Okay, is okay, is going to be filed by tomorrow. By tomorrow. Okay. By tomorrow. And these cases be listed, both the cases be listed, and has paid for listing of both the cases on Tuesday. First up, the prayer made by Mr. Gogoi is accepted, list the cases on 8/4.
Very much.
I take this, Radhakishan. কিতাপখন দিব। এই ইয়াতে section. Okay, what are the section 83 and
83 Rule 159, Lordship, and Form GST.
and other any other provision in related to the other case?
No, this will cover, madam. Same issue.
Section 83, Lordship, Rule 159, Form DRC 22. These three things.
Form
DRC 22.
এটা page xerox করে দেব মনে কিতাপবোৰ খুলি থাকে। It is very difficult to open the books in the
In
court.
Form 23, it has been mentioned that, madam, there will be no debit. That is why I put that is specific.
No, your instruction is very specific, debit fees.
I appear for the petitions. So this matter was regarding the show cause notice issued for financial year 2021 being time barred under the statute. In the meantime, Lordships, on last occasion on 27th of February, when this matter came up, then it couldn't be taken because of paucity of time, and they had passed the order also. We have shown. But on the next day, they have also given a letter that because the High Court order was there not to proceed further, but we had passed the order, but we will not take any course of action. Lordship, so my challenge is, Lordship, to a show cause dated 29th of December 2024, 29th of November 2024.
Go chronologically first.
Lordship, section 73 of the
Okay.
CGST or Act, or the any Act, Lordship, CGST or the Assam GST, any Act you may take, Lordships.
There is an interim order already.
Interim order was not to be proceeded with. No order to be passed, but what they did, because I explained, Lordship, that 28th February was the last date, so they passed the order.
Let us understand the case.
Lordships,
Then only,
Was a system generated order, immediately we have stayed it.
Lordship, that is what. Lordship, section 73. Section 73, subsection 2. May I please, Lordships?
let me read subsection 1, I forget everything.
Lordships.
Yes.
73 2, Lordships. The
Hmm.
proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. That is means, Lordship, the time limit to issue show cause is linked with the time limit to pass the assessment order under section 73(10). Now, may I place 73(10) for once, Lordships?
Hmm.
73(10) says, Lordships, the proper officer shall issue the order under subsection 9 within 3 years from the due date for furnishing of annual return for the financial year to which the tax paid or short paid or ITC wrongly availed or utilized relates, or within 3 years from the date of refund. So, Lordship, the outer date to pass the order is 3 years from annual return. Lordship, my period before your Lordship is financial year 2021.
Okay, 2020.
2021. 202/2021.
Yes.
Lordship, section 44 is the section for annual return. May I take
Section
44? May I take your Lordship to section 44?
Yes.
Lordship, section 44, subsection 1. Every registered person other than an input service distributor, a person paying tax under section 51 or 52, a casual taxable person, and a non-resident taxable person shall furnish an annual return which may include a self-certified reconciliation statement reconciling the value of supplies declared in the return furnished for the financial year with the audited annual financial statement for every financial year electronically within such time and in such form and in such manner as may be prescribed. Now, this prescription is given under Lordship's Rule 80.
Rule 80.
Rule 80 of the CGST rules.
Yes.
May I please, Lordship? Rule 80, sub rule 1. Every registered person other than those referred in the second proviso to section 44,
Just a minute.
Lordship.
Rule 80 is with
For annual return, for section 44,
44.
Lordship.
1 minute.
Okay. 73 to 10,
Ah.
then 44, Lordship, then rule 80.
Yes, rule 80.
Lordship. Rule 80, sub rule 1. Every registered person other than those referred to in the second proviso to section 44, an IA input service distributor, a person paying tax under section 51 or 52, a casual taxable person, and a non-resident taxable person shall furnish an annual return for every financial year as specified under section 44 electronically in form GSTR 9 on or before the 31st day of the December following the end of such financial year. I stop here. So the due date to furnish annual return in form GSTR 9 is 31st December of the next year. So for 2021 Lordships, it was 31st December
31st December
2021.
next year.
Next year.
Huh?
Now Lordships may kindly take
Follow,
some
1 minute.
Lordships.
Following the end of such financial. Now, if it is financial year 2020, 21.
Lordship, then it will be 31st
That-
December
That ends on 31st March 2021.
Lordships.
Then what will be the date?
31st December 21.
Okay, date of filing
GSTR 9 annual return.
GSTR 9 is
31st December 2021.
Yes,
Now, Lordship, Rule 80, Sub Rule 1A,
Rule 80.
Sub Rule 1A extended this time for this financial year, which we are concerned.
Rule 1A.
May I place, Lordship?
Yes.
Notwithstanding anything contained in Sub Rule 1, for financial year 2021, the said annual return shall be furnished on or before the 28th day of February 2022. So, Lordship, for 2021, they extended it to 28th of February 2022. Now, Lordships, if we take this date of filing of annual return as 28th February 2022, having regard to section 7310 now,
Hmm.
7310 says, Lordships, assessment order has to be passed within 3 years from this date, which is 28th of February 2025.
Okay.
That is for 7310 Lordships. That assessment order under 7310 to be passed within 3 years from my date of annual return.
Yes.
No, Lordship, if the last day to pass order was 28th of February 25, having regard to 73.2 now, 73.2 says at least 3 months prior to the order date. 3 months prior, Lordship, the words of 73.2 is very important here.
May I read Lordship 73.2 once? The proper officer shall issue notice under subsection 1 at least 3 months, then it is prior to the time limit. So minimum 3 months and prior. So Lordship, 28th February 22, if I go back 3 months, it will be 28th of November 24. And prior would signify, Lordships, at least prior to 28th November would signify last date should be 27th November. Because the word used is prior, Lordships, at least and prior. So, Lordship, if or read now, Lordship, the issue. Post. Lordship, we were at section 73.10. After on reading of section 44, read with rule 81A, the due date for annual return for 2021 was, Lordship, 28th of February 2022. We stopped at the Lordships. Section 44, read with rule 80, sub rule 1A, extended the time period of GSTR 9 annual return for financial year 2021 up to 28th of February 2022.
Yes.
81 here, Lordship. Now, Lordships, if we go to section 73.10, 73.10 says, Lordships, the proper officer shall issue an order under subsection 9 within 3 years from the due date of furnishing of annual return. Lordship, 3 years in my case would be 28th of February 2025. Time limit to pass order under 73.10. Because it is 3 years from the due date of annual return, which was extended up to 28th of February 2022. So 3 years would be 28th of February 25. Now, Lordship, 73.2. 73.2 says the proper officer shall issue notice under subsection 1 at least 3 months prior to the time specified under subsection 10. So, Lordship, from 28th February 25, if it's the due date to pass the order for 2021, 3 months would be 28th of November 2024. Because, Lordship, the key point here is, Lordship, the meaning of the word month. It says, Lordship, at least 3 months prior to the time limit specified under subsection 10. So 3 months, Lordship, would be 28th of November 2024, and prior to that date would mean 27th of November 2024. Now, Lordships, there is no definition of month in the GST statute. So one has to take reference to, Lordship, General Clause Act, which says month in the case, if it is not defined specifically, it is to be taken as a British calendar month. And Lordship, this particular issue came up before consideration before the Honorable Andhra Pradesh High Court, like for the same financial year. And the Honorable Andhra Pradesh High Court has held that month would mean that date of the same month. It cannot be taken as days.
Yes, one honorable High Court judgment is here.
Lordship, I prepared a compilation. Lordship told me last day to prepare a compilation. Lordship, page number 7, para 9 of the judgment. Page number 7, Lordship, para 9. May I please, Lordship? The Honorable Supreme Court, while considering the issue and after noticing that Section 3, subsection 35 of the General Clause Act, the 1897 defines a month as meaning a month reckoned as a British calendar, has also noted the judgment of the House of Lords in Dodds versus Walker. The House of Lords, while considering the period within which a tenant can approach the court under the Lordship, Landlord and the Tenant Act 1954, observed as follows. So I am skipping that. That's not it. Para 10. The aforesaid judgment clearly laid down the principle that when a period available for a certain action is defined in terms of months, it would mean the corresponding date of the corresponding month would be the cutoff date. In the present case, the cutoff date for issuing an order is 28th of February 25. This also dealt with 2021 Lordships. The 3 months period which would elapse from this date would be 28th of November 2024. Since the notice was issued on 30/11/24, it would be beyond the time stipulated under 73(2). Lordship, post this, the Honorable Bombay High Court also recently has taken note of this, Lordships, and as though it's an interim order still, Lordship, but the issue, the nature of the issue is same.
No, interim order is not final order.
No, it's not a final order, Lordship, not final. It has just noted the contention of the under pressure.
We'll not take note of this until it is decided.
Lordship. Now, Lordships, in my case, the show cause notice is at page 49 and Exhibit 3.
Any the other decisions?
Other decision, Lordships, Honorable Allahabad High Court, Lordship, at page 36 may come. It is in the erstwhile service tax regime, similar provisions were there, Lordships.
Where is the reasoning?
Lordship, para 6 of the said judgment.
Page
37, Lordships.
36.
Page 37, para 6.
Page 37, paragraph 6.
May I place, Lordships?
1 minute.
Lordships.
Yes.
In our view, the question does not suffer from any ambiguity. In construing fiscal legislation, the duty of the court is to interpret the statute and the language used by the legislature by giving to it a plain and natural meaning. Significantly, where the legislature intends to define the period of limitation with regard to number of days, it does so specifically. In the case of the Act of 94, Section 85 has defined the period of limitation as well as the power to condone the delay with regard to a stipulation in terms of months, and such a stipulation can only mean a calendar month. Once the legislature has used the expression 3 months, both in the substantive part of the subsection 3 of 85 as well as in the proviso, it would not be open to court to substitute the word 3 months by the word 90 days. To do so would mean amount to rewriting the legislative provision, which is impermissible. And again, then, Lordship, the General Clause Act is referred in para 7, and in para 8, the order is there.
Let us see this.
Lordship, may I place para 7? The expression month is also defined in section 3, subsection 35 of the General Clause Act 1897 to mean a month reckoned according to the British calendar. The issue before the court is not res integra. A similar provision came up for consideration before a bench of 3 learned judges of the Supreme Court in Tamil Lahiri versus Kumar P. and Tagore. In that case, the provision of section 533 of the Bengal Municipal Act stipulated a period of limitation for filing a prosecution under the Act by providing that no prosecution for an offence under the Act shall be instituted except within 6 months next after the commission of such offence. Explaining the import of expression 6 months, the Supreme Court observed as follows. The only question which then requires examination is whether the prosecution which was filed on June 19, 1968 was instituted as required by section 533 within 6 months from next after the commission of the offence. An argument was raised in the High Court that 6 months must be construed to mean 180 days and not 6 calendar months. The High Court does not appear to have accepted the submission. There, the High Court is right. Because Section 3, subsection 27 of the Bengal General Clause Act defines a month to mean a month reckoned according to British calendar. The expression 6 months, which occurs in Section 533 of the Act, must accordingly be construed to mean 6 calendar months and not 180 days. So, Lordship, in GST, there is no definition of month. Month is not defined. In the offense being alleged to have been committed on the expiry of December 20, 1967, and the prosecution having been instituted on June 19, 1968, the provision of 533 must be held to have been duly complied with. In that case, it was 6 months. So within that 20th December to 6 months would be 20th June. So it was done on 19 June, so it was held to be correct.
Yes.
Lordship, I will refer to one more judgment in my petition, Lordships, page 71, Supreme Court, State of Himachal Pradesh, which is Himachal Techno.
This High Court judgment, Andhra Pradesh, is based on another Supreme Court judgment.
Lordship, that is what I was referring now. This Techno, State of Himachal Pradesh, para number 7, that I have attached in my compilation also.
Okay.
Lordship, may take page 39 of the compilation. My Lordship is there. Lordship, the relevant para in that would be para 14. May I place before your Lordship?
Yes.
Para 14. The High Court has held that 3 months mentioned in section 34, subsection 3 of the Act refers to a period of 90 days. This is erroneous. A month does not refer to a period of 30 days, but refers to the actual period of a calendar month. If the month is April, June, September, or November, the period of the month will be 30 days. If the month is January, March, May, July, August, October, or December, the period of the month will be 31 days. If the month is February, the period will be 29 days or 28 days, depending upon whether it is a leap year or not. Subsection 3 of section 34 of the Act and the provision thereto significantly does not express the periods of time mentioned therein in the same units. Subsection 3 uses the word 3 months while prescribing the period of limitation, and the provision uses the word 30 days while referring to the outside limit of condonable delay. The legislature had the choice of describing the periods of time in the same units, that is, to describe the period as 3 months and 1 month, respectively, or by describing the period as 90 days and 30 days, respectively. It did not do so. Therefore, the legislature did not intend that the period of 3 months used in subsection 3 to be equated to 90 days, nor intended that a period as 30 days to be reckoned, to be taken as 1 month. Section 3, subsection 35 of the General Clause Act defines a month as meaning a month reckoned as according to a British calendar. In Dodds versus Walker, that is same extracted in the judgment of Lordship Andhra Pradesh High Court. Para 18, therefore, we have when the period prescribed is 3 months, as contrasted from 90 days from a stipulated specified date, the said period would expire in the 3rd month on the date corresponding to the date upon which the period starts. That is my point, Lordship.
Okay,
So,
I'll just put a hypothetical question.
Lordships.
Hypothetical. Assume it is not up to 28th February 2025.
Lordships.
Let it be 31st May 2025.
31st May 25. Then 3 months before that, then
Because here we are not traveling forward,
we are going backwards.
we are going backward.
And that is why Bombay
All these decisions
Lordships.
are, at least Supreme Court decision is going forward,
Forward.
right?
Lordships.
Calculation of the period.
No, Lordship. That last line that we read in the Supreme Court judgment, may I just read once more, Lordship?
That 90 days, 80, 90
No,
days.
Lordship. The last para 18. Therefore, when the period prescribed is 3 months from a specified date, the said period would expire in the 3rd month on the date corresponding to the date.
That is why I am asking.
The same
That
date.
is why I am asking it
Lordships.
to Mr. Kanodia.
Lordships.
If
31st May.
31st May.
So, Lordship, 3 months
you
back.
do.
So, April, March, February. February, March, April. So, it will be 28th or 29th February. it will be 28th or 29th February. Lordship, why I say, I'll give you another example in GST. For 17-18 Lordships, this annual return time was extended up to 5th of August. 5th of August 2020. That was extended by the government. Lordship.
Any example except the Andhra Pradesh High Court? Going backward.
Lordship, Calcutta High Court has given a stay. With not final.
Final.
Lordship, final is Andhra Pradesh today. Bombay has relied and Bombay has noted.
No, delaying is different thing.
No, Lordship, Bombay has taken.
No, I'll not go into interim orders, please.
Lordship, I'm not asking. Lordship. I just, whatever is there.
Anyway, this Andhra Pradesh High Court judgment will have persuasive value.
Oh, I go down to Lordship. It is not.
So any Supreme Court decision.
Supreme Court not on backward, Lordship. Supreme Court Finance Act, I saw, Lordship, because it was service tax. This is GST. What the interpretation Supreme Court has brought is that when a month is not defined under the statute, you have to go to the General Clause Act. General Clause Act would mean the same date corresponding to that. Lordship, I'll take one example, Lordship, because what has happened? If, Lordship, if it was 31st of December, because general, the due date was 31st of December of the next financial year. So 3 months would be 31st of March, or if we go backwards, it would be 30th of September. And department has not disputed it. Why I say so, Lordship? This we are concerning 2021. If we see other financial years prior to this, specific example is of 17-18, Lordship. 17-18, the due date to issue show cause notice was 5th of August 2024.
We are into interpretation of 73-2,
73-10. I'm only on that.
And Rule 80.
Rule 80, sub-rule 1.
One and two, whatever.
Lordship, my point was for just 1 minute, I'll take off your Lordships. Why? What did the government did? Government stated, okay, for 17.
Let us see what is the facts.
Facts, Lordship. Lordship, that I was placing, Lordship. Kindly takes page 49, which is the impugned show cause notice. Page 49, Lordship, is a form DRC 01, which is a summary of the show cause notice. Top right-hand side, the date is given 29/11/2024. So, Lordship,
yes.
In my case, this notice has been issued on 29/11/2024, which I say is beyond the jurisdiction of the proper officer to issue the notice. Because I am challenging the show cause, Lordship, because I'm not on the merits of the matter that what are the ingredients of the show cause notice. I am only on the date, Lordship. So my submission would be, Lordship, that when the legislature has not defined month, then the General Clause Act would apply, and on the interpretation of General Clause Act, it would be that day of the same month, either backward or forward. And that, taking into account the same, the Honorable Andhra Pradesh High Court has, for the same financial year, has held that it would be 28th of November 24. Wherein my plea before your Lordships is today, if you read 73-2 once more, Lordships, may I play 73-2 once more? The proper officer shall issue notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10. So, Lordship, 2 words, at least and prior. At least 3 months would mean 28th of November 24 in my case. And prior would mean at least 1 day prior to it.
That is your contention.
Lordship, that is my contention, of course. Andhra Pradesh High Court has held it to be on 28th of November only.
I have seen. Andhra Pradesh, I have seen.
Lordship. So, now, my case, it is not disputed. They have issued on 29th of November 24. Therefore, I am before your Lordships challenging the jurisdiction that this particular proceedings is itself bad. Another point of contention is that 73(2) is mandatory. That was also considered by the Honorable Andhra Pradesh High Court in the subsequent part that 73(2) is mandatory.
What is rule 80 again?
Rule 88,
80 or 80 only?
80 Lordship, annual return. 80 is Lordship, we went to 80, the prescription of the section 44, that it has to be filed within 31st December of the next financial year. And by sub rule 1A for 2021, which is the impugned period before your Lordships, it was extended up to 28th of February 2022. I have attached that notification also, Lordship, at page 27, that extension notification.
Okay, going forward, if the interpretation given by the Supreme Court,
Lordships.
suppose the notice under section 73(2)
Lordships.
issued on 28th of February 2025.
Look, any day, 28th of February 25.
25.
Lordship.
Then what will be the date?
Of passing the order. So, Lordship, passing the order is linked with annual return, not issuance of show cause. It is vice versa. Lordship, kindly appreciate 73(10) first.
No, I have understood.
Lordships. So
It is
first,
not that I have not understood it.
Lordship, I am placing that.
I am asking a query.
Lordships.
Suppose the notice has been issued
Lordships.
on 28th February 2025.
Lordships.
Then this 73(10)
Lordships.
says about 3 months. 73(2) at least 3 months prior,
Prior to what?
and 73(10)
3 years.
says about 3 years.
3 years of the annual
So
return.
this is linked.
It is backward.
73. I know.
Lordships.
I
I appreciate Lordship, sir. Lordship is given an example. I have
And
taken that.
I am not saying I am going forward.
Lordship,
Just
yeah.
for a moment, for the
Lordship.
sake of understanding the concept.
Lordship. 28th February show cause issue.
Huh. If it is suppose as per section 2 within bracket 35
Lordships.
of the General Clauses Act,
Lordships.
the 3 months period is to be counted.
Lordships.
And going by the interpretation of Supreme Court,
Lordships.
what will be the 3 months period ending?
Ending period would be, Lordship, 28th February 25 to 3 months would be 28th March, 28th April, 28th of May 2025.
Wrong. Supreme Court judgment. Come to
Lordships.
that Himachal.
Himachal, Lordship.
Sir,
Yeah, Himachal, Lordship.
come
Para,
to Himachal.
para number, Lordship.
You have read?
I have read para 18, Lordships.
Huh.
Page 44.
So, if it is 18,
18, Lordships.
now from a specified date. The period would expire on the third month on the date corresponding to the
To the-
date upon which the period
Starts,
starts.
So
As a result, depending upon the months,
Lordship.
it may 90 days, 91 days, or 92 days, or 89 days.
I go down to it, Lordship.
Now, come to this interpretation of board or what, that foreign judgment.
Lordship, that is at page number, para 17. Oh,
Read para 9
para 9,
of Andhra Pradesh.
Andhra Pradesh. The Honorable Supreme Court
In between.
in the italic,
Such was the instant case.
such was the
And
instant case.
such will
And
be
such will be
every other case, except
for the notices given on
given on,
the 31st or of a 31 day month,
okay, given on the 31st
given on 31st,
day of a 31-day month
Lordships.
and expiring in a 30
Day
day
month
of month or
30
in
day month.
February,
or in February. And notices,
expiring in February and given on so and so and so and so except leap year of any other. What do you say about this?
Lordship, it says
What
what?
do you say about this?
It says that even suppose the outer date is 31st, but if the expiring date moving forwards also, as per your Lordship example, that particular month is not having 31st, or say that particular month is February, it would still mean that date of that month. This is the interpretation. Lordship, I'll read. Just Lordship, allows me 1 minute to read it by breaking. The simple this simple general rule in this is in accordance with common usage. Such was the instant case, and such will be every other case except for notices given on the 31st of a
Yes,
31-day month.
Perfectly well.
May I read? I'll pause.
You read
Lordship.
so long as there is in the month in which the notice expires a day which bears the same number as the day of the month on which the notice was given. Such was the instant
So same day available.
available.
Such was
And such will be every other case. Every other
every other except
except for notices given on the 31st
of
of
a
a
31-day month.
1-day month.
Means March. Say March. March is a 31-day month. So notice is given on 31st March.
And expiring in a 30-day month.
So say it is 1 month period is there. It expires on 30th April. Because in April there is 30, no 31st.
That I have answered.
Or no,
Or
in February. Because February is either 28 or 29, Lordship has seen that. And notices expiring in February and given on the 30th or 29th, except in the leap year, of any other month of the year.
Hmm.
So they say,
in these exceptional cases, the modification of the corresponding date rule that is called for is also
Well
established. The period given by the notice ends upon the last day of the month in which the notice expires.
Lordships.
What do you say about this?
So
You have been heavily relying upon this.
I am relying on this still, Lordships. My point of
So you are relying upon this Dodd versus Walker.
that is being relied by Andhra Pradesh.
That is interpreted in that manner
Lordship. So
in
my
paragraph 10.
Lordship, I
But
am,
this peculiar situation has not been interpreted by Andhra Pradesh judgment.
Lordship, Andhra Pradesh, of course, it is not binding on your SSC. I placed it. Your Lordship may differ.
No, I am putting the query
Lordship,
just to remove the
Understood.
cloud,
We are discussing, we are to
remove the
interpret
cloud.
Lordship.
That's all,
That's all.
right?
So, Lordship, the interpretation to this, what
So
to my
this is
small knowledge,
very, yes, but this is very
Lordship,
well
English,
illuminated
that is what in Dodds and
interpretation.
is House of Lords, what they have decided at that time.
That
That is why,
because
Lordship, I am not,
our English cannot be compared with their English,
of course, we can.
right?
So Lordship,
And
my point was, what is
this,
this?
let us read once
Once,
again,
once.
right? So, because I don't understand easily.
Lordship, we don't understand that also, how much your Lordship can understand it.
So, see, let us read slowly.
Lordship,
The simple general rule in so and so in Freeman described as being in accordance with common uses and with the sense of mankind works perfectly well without need for any mankind. So long as there is in the month, means the next month, perhaps, if I have understood correctly, in which the notice expires a day which bears the same number as the day of the month on which the notice was given. We are forward look,
forward.
right?
31st,
Such
31st.
was the instant case. So that was their case. And such will be every other case. So this is the general
General practice.
practice.
Common uses they
Now,
referred.
the exception.
Lordship.
Except for notices given on 31st of a 31-day month, right?
Lordship.
And expiring in a 30-day month. So this example is, say it is 31st December, and after 3 months, it will be 31st March.
After 3 months, it will be 31st March.
We are not taking your case. We are not taking it.
It's an example, what your Lordship, I beg to differ slightly of this line.
For notices given on 31st day of a 31-day month.
31st March.
Take your pick.
31st March.
March. And 1 month, say. 1 month.
And
1 month. 1 month.
1 month.
So, expiring in a 30-day month. So, it will be April.
30th April.
Okay, this is one example.
This one.
Right?
Right.
Keep it aside.
Lordships.
Right?
Lordships.
Then again, except for notices given on the 31st of a 30-day month and expiring in February.
Lordship.
You keep it aside. 30-day month, we have decided
Decided.
already.
Decided.
We have kept it aside.
And notices expiring
Or-
in February.
In February, and notices expiring in February. This is one part. After February it is comma.
Lordship,
So it is
That is finished.
finish. So, and next one, notices expiring in February and given on 30th or the 29th. 29 is for leap year.
Leap year.
Except in leap year. Of any other month of the year. What do you mean by this?
Lordship, if we-
Notices expiring in. Oh, this is 1 minute. Such was the instant, and such will be the every other case, except the notices given on 31st of a 31-day month and expiring in 30 or in February. Okay, this is one part. Then notices expiring in February and given on 30th or 29th of
So this is-
any other month of the year.
Specifically, they are discussing February month.
Ah.
Specifically February month,
Ah.
if the last date of the
So-
notice is February,
Okay,
but the notice is given in, say, April, in January.
in these exceptional cases, the modification of the corresponding date rule, which you are arguing, 28 means, 28
28.
February means 20.
Exact date of the same month,
November,
November.
right?
No.
This is your
This is my
argued case.
Lordship.
In these exceptional cases, the modification of the corresponding date rule that is called for is also well established. The period given by the notice ends upon the last day of the month in which the notice expires.
That is, basically, they are seeing for month of February. They have dealt this particularly for February. So if any other period notice has been issued, but expiring on February, so it has to be 28th or it cannot go beyond February.
This exception part is not discussed well discussed by the honorable judgment.
Lordship, next paragraph, they say the aforesaid judgment clearly laid down the
No.
principle that when a period available for action is defined in terms of month, it would mean the corresponding date of the corresponding month would be the cutoff date. That is what has been interpreted. Lordship's way, of course, not binding. Lordship, first I go down again. Your Lordship's way interpret as per your Lordship. At least something will be settled.
No, we are trying to understand.
This Lordship, the problem is this is the paragraph of the
Because
judgment.
this paragraph 10,
This paragraph is something. This 9 extract of this dots and vocal Lordship is something beyond what we are
because
trying to do.
here is a peculiar situation.
Lorships.
Out of all these 12 months, February is an exceptional month.
Lordship, that is why I was just trying to
And
give.
that is also, it changes every 4 years.
But I was trying to give an example of 1718, which would clear the intent of the GST legislation. If your Lordship allow me 2 minutes to submit on 17.
Because 73, it says about 3 months, 73 to says about at least 3 months prior.
Prior.
And 73 says about
7310 says about 3 years from annual.
nothing is about days.
Nothing about this.
We have to understand that also.
Yes.
And nothing is about days. But rule says, from rule you can pick up something, but it has to be correlated with section 73.2 and 73.10. Rule cannot go beyond
Never.
the statute.
Then it will be bad.
Yes,
OTF.
80 sub-rule 1. Why they have picked up this 31st December, right, following the end of the financial year? The answer will lie in 73, section 73 only,
7310.
10.
The proper officer shall issue order within 3 years from the due date of furnishing annual return. So the legislature has given immediate due date. Okay, by this date you have to file your annual return.
Officer shall issue the order within 3 years from the due date of furnishing to which. Okay,
So Lordship,
so this is the date,
Lordship, this is
31st
the-
December,
section 44.
following the,
The
okay, let us see again 44.
44 Lordship, kindly takes 44 once. Every registered person other than an ISD, a person paying tax under 51, 52, a casual taxable person and a non-resident taxable person shall furnish an annual return which may include a self-certified statement.
Okay, last part.
Lordship,
Within such time.
within such time and in such form and in such manner as may be prescribed. So Lordship, that prescription is under Rule 80. Is the form GSTR 9. Time is 31st December for every financial year, end of the financial year. Now 81 is specifically for the impugned period, extends it up to 28th of February 2022.
So 28 February 2022
Lordship,
is the
annual return due date.
due date.
Now Lordship comes to 73 once.
Due date. So 28 February 2022.
Due date to furnish GSTR 9.
So this
7310 now Lordship.
10.
10.
So this due date of furnishing annual return is 28 February 2022.
22. So 7310 says Lordship, the proper officer shall issue an order within 3 years from the due date.
Now we have to go back from section 7310,
Lordship.
reading it as 28 February 2025.
Because they have accepted that.
No.
They passed the order on that day. In my case,
No,
keeping the proceedings pending,
no, we are not going into your case.
Lordship, general.
We are understanding the
Understand.
concept.
So,
So
I again read,
section 7310
Lordship.
requires, in view of this amendment in Rule 80,
Lordship, by Rule 1A, inserting by Rule 1A.
the date or due date of furnishing of annual return for the financial year is, for that particular year is 28 to 8 February 2025.
22.
28 to 2000.
22 is the due date of annual return.
Okay.
3 years from date.
No, this
order,
7310.
lordships, it is your
The
lordships correct.
proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing the annual return for the financial year.
Lordship.
So from 28th of February 2022, we have to travel for 3 years more.
More,
That goes, we reach milepost of 28 February 2025.
Good.
Then in view of section 73(2),
lordship,
we have to again move backward for 3 months.
3 months.
And that is where the
Interpretation,
answer lies.
3 months, yes, lordship.
This way or that way. According to you, it is 28.
Lordship.
I don't know what is the person. If
Yes.
he agrees, well and good. Then still the answer is to be given by the court.
Lordship, I go. Nothing more, lordship, sir.
So far as the facts are concerned, it is clear, provisions are clear, he has already clarified. I would like to, because the honorable court to.
Any judgment moving
Yeah,
backwards.
No, my lord, yes, moving backward, reverse calculation is not there, but my lord,
Okay.
from this principle, whatever has been laid down by the Honorable Supreme Court, I will demonstrate that, my lord, the date, cutoff date will be 30/11/2024. The lordship will have a look at page 44 of this compilation, my lord, he has read out, my lord, 18, para 18. I would like to read it again and 19, including 19. 18 says, therefore, when the period prescribed is 3 months, as contrasted from 90 days, from a specified date, the said period would expire in the 3rd month or on the date corresponding to the date upon which the period starts. As a result, lordship will mark these days, my lord, depending upon the months, it may be 90 days, 3 months it will be 90 days, 91 days, 92 days, and 89 days.
Hmm.
Now, my lord, this 90 days will be, my lord, otherwise, my lord, just for sake of my lord argument. 90 days will come, my lord, supposingly it starts from December, ends in February.
Hmm.
December, it is 31 days, January 31 days, February 28 days. So it is 90 days. Same, my lord,
Hmm.
January, February days will come, my lord, in say, my lord, September 30 days. October 31 days, November 30 days, so it is 91 days. Likewise, my lord, 92 will come, my lord, in various months, my lord, 3 months if it is taken together. Say like, my lord, November, December, January, 30 days, 31 days, 31 days, it is 92 days. 89 days will come, my lord. In the present case, it will be 89 days, my lord. February, March, April, say, my lord. February, March, April. February 28 days, March, my lord, 31 days, my lord. April 30 days, it is 89 days. Now, lordship may look at now para 19 for a moment. How to calculate that has been given in 19. As the award was received by the executive engineer on 12/11/2007 for the purpose of calculating the 3 months period, the said date shall have to be excluded having regard to section 12(1) of the Limitation Act and section 9 of the General Clauses Act 1897. Consequently, the 3 months would be calculated from 13/11/2007 and would expire on 12/2/2008. So we'd like to stop here, my lord, since our case is only limited to 3 months. Here, my lord, another 30 days there in the Arbitration Act, my lord. So how it is, lordship will see, my lord, going by these 2 days, it seems that, my lord, yes, it is corresponding date will be on the next 3rd month, my lord. That is, my lord, lordship will see 12/11, 12/2/2008. How is it possible, my lord? In fact, my lord, this Honorable Supreme Court is otherwise, my lord, correct in that sense, even if we calculate that loss. May I place the calculation now?
Problem is the General Clauses Act also has not
Yes, ma'am.
answered it.
Not answer.
My lord, we'll see, my lord.
Everybody was looking forward, or everybody was forward looking,
Forward only. No, I
no
will,
backward
I will
looking.
give the reverse also, my lord. Let us understand this part, my lord.
Okay.
Whether it will be exactly corresponding, my lord, in the 3rd month. Forward counting, my lord. Let us take this example in, my lord, para 19, my lord, these dates. Here, my lord, the notice was received on, my lord, 12/11/2017. So it is a November month, my lord. 3 months period, my lord, as per para 19. November 30 days, December 31 days, January 31 days. So total is 92 days. As per para 18, there it is possible. Now 12/11/2007 is the date my lord mentioned here when the order was received. So my lord, calculating 92 days, my lord, Lordship will see it will start from the next day. From 13/11/2007.
Which one? Which page?
My lord, that calculation.
First page.
First page. Sir.
Hmm.
This calculation relates to this, my lord, Supreme Court judgment. my lord. So 12/11/2007. So we'll have to count it from 13/11. It has been mentioned in para 19. So from 13/11/2007 to 30/11/2007, that is the November month, it comes only 18 days.
Hmm.
From 1/12/2007 to 31/12/2007, it is 31 days, my lord. From 1/1/2008 to 31/1/2008, it is 31 days. Now if we calculate this, my lord, it goes to 80 days, but my lord, it will have to be 92 days. So we'll have to count, my lord, another 12 days from the next month. So my lord, since my lord, the other month ends at 31/1/2008. So from my lord, 1st of February, 12 days will be exactly 12 to 2008. It is corresponding day of the next third month.
And that has been
Now, Lord, let us see
decided by
the next
Saket
page.
India and all.
No, Lord,
It is already there.
following the same analogy, in the next page is the reverse calculation in the present case. It will not be same. My lord. Lord, you will see, my lord, reverse counting for 3 months. In our case, my lord, you will see the date, it is 28 to 2005. I have given, my lord. So February, reverse counting, my lord, February, January, and December. February 28 days, January, my lord, 31 days, December 31 days. It goes to 90 days. We'll have to take up 90 days. So it will start from the next, reverse calculation. It will start from 27 to 25. To 1 to 2025, it is 27 days. From 31/1/2025 to 1/1/2025, again 31 days. In December, my lord,
Something is wrong.
31/12/2024 to 1 to 2024.
So in order to complete that part,
Yes, so in order to.
One day
complete,
we'll have
we
to add
followed
it.
by 1 day, so it will be 30/11, my lord.
will be the day before so and so. Since it is reverse counting, a day will be 30/11.
Now, my lord, for a moment, my lord, hypothetically, let us, my lord, take that, my lord, 73(2) says there, it will have to be 3 months from the date of notice. Then what will be the date? Following para 19. Next page is the calculation. It will be exactly the corresponding date. If we calculate forward. But when it is a reverse calculation, it will be different.
Hmm.
Lordship will see it is a forward calculation. February, my lord, it is 28 to 2005, my lord. If we calculate forward, my lord, it will end in, my lord, April. It will have to be 89 days. Say, my lord. So Lordship will see, my lord, 2 months we have calculated, it goes to 61 days, my lord. Now, from 89 days, we are short by, my lord, 28 days. So in the next corresponding month, exactly, it will be from 1 to 1/5/2025, it will be 28/5/25, my lord. It will be corresponding, my lord, in case of forward calculation, my lord. But when we go reverse, my lord, it will be different, my lord, following the same analogy. It will be on 30/11. That's why, my lord, we have stated that we have issued within time on 29/11 because. So it may be, my lord, 90 days, 91 days, 92 days, or 89 days.
So every discussion is about forward,
So every discussion.
not backward.
There are 2 of, my lord, 3 months in this particular judgment of the Honorable Supreme Court. That was
Yes,
my-
Mr. Kanatiya,
Lordship.
any judgment regarding
Not
backward.
that, but Lordship, what my learned friend has submitted to that, my learned friend has gone into days. This is what Supreme Court exactly says, page 37, Lordship, takes my compilation. Supreme Court states, page 37, para number 7. In the Allahabad High Court judgment, the judgment of Supreme Court is extracted. Kindly takes that, Lordship. Page 37, para 7. Why we cannot go into days? That is the point, Lordship. May I place para 7? Lordship? Para 7, page 37. The expression month is also defined in 3 subsection 35.
Para?
Para 7, Lordship, page 37. The Allahabad High Court judgment, the relevant extract I am just reading, para 7. The expression month is also defined in 335 of General Clause Act to mean a month reckoned to a British calendar. The issue before the court is not res integra. A similar provision came before a bench of 3 learned judges of Supreme Court in Tamil Lahiri versus this. In that case, the provision of 533 of the Bengal Municipal Act stipulated a period of filing of prosecution under the Act by providing that no prosecution shall be instituted except within 6 months next from the commission of offence. Explaining the import of the expression 6 months, the Supreme Court observed as follows. The only question which then requires examination is whether prosecution which was filed on June 19 was instituted as required by section 533 within 6 months next after the commission of the offence. An argument was raised in the High Court that 6 months must be construed to mean 180 days and not 6 calendar months. The High Court does not appear to have accepted that submission. The High Court is right because 327 of the Bengal Clause Act defines a month to mean a month record according to a British calendar.
That's what we have taken.
The expression 6 months which occurs under 533 must accordingly be construed to mean 6 calendar months and not 180 days. Now, Lordship, if going by this calculation, it is counting days.
Yes.
We cannot go into the days. That is what Supreme Court says again and again. It is up to the same date of that month. The question of counting 89 or 91 or 92 does not arise at all when the legislature does not define month and when we go and take reference to General Clause Act. That is my only submission to my learned
There are
seniors.
18, my lord, is very clear. It says, my lord, as a result, depending upon the months, it will mean 90 days, 91 days, 92 days, 89 days. And this particular judgment, my lord, that he has referred to, it says, my lord, 6 months will be 180 days. That was the contention, my lord. Honorable Supreme Court is clear. It will have to be counted as a calendar month. It cannot be taken up as a 30 days per month, my lord.
Your Lordship, that is what the Andhra Pradesh also then deals and says ki yes, when it is cut-off date, that cut-off date will be that date. Your Lordship, may kindly take para 5 of the Andhra Pradesh judgment, Lordship. That is the exact argument of which my learned friend has placed here. Page number 5 and para 5 of the compilation. Exact the same argument was placed before the Honorable Andhra Pradesh High Court.
Try to find out any instance of going backward.
Lordship, I researched, Lordship. Since December, I've been researching on this. There's nothing. I
I
couldn't
can
find.
afford, we'll keep it part heard, but this is not answered by the
Lordship,
Andhra
kindly
Pradesh.
take para 5 once for the moment.
that is argument perhaps.
Lordship, yes. The learned government,
Finding is at paragraph 10.
finding the Lordship has seen already. May I please, Lordship? Para 5, page 5. The learned government pleader would contend that a month would mean a calendar one, as the 20th February is the end of the month of February. The last day of issuance of notice would have 1st December or at the worst 30th November. As the notice has been issued on 30th November, it would be within limitation.
I have given the calculation, my lord.
Lordship, that
Not
is
the
why
time that you see.
my point is, Lordship, we cannot go into the calculation because the legislature uses the word month and month is already clarified by Supreme Court at various instances that you cannot go into days. Had the legislature intended days, then that calculation is very well valid. But when there is no legislature is not giving days, it has to be read as month and month would be that date only. That is my only submission. Lordship, may I reserve it for orders, Lordship. There is nothing more which I would be.
No, if you can furnish something on backward,
Lordship, I have,
then
Lordship,
we'll keep it, otherwise we will not hear you.
Lordship, because I
Okay.
tried, Lordship, I filed this in the beginning of December. From that time, whatever I could have got, I have brought. Your Lordships will decide. Either this way, that way, that way. That is other thing, Lordship, but that is something your Lordships will decide on this.
This judgment has also relied upon this Himachal.
Which will not. The
This
Andhra
Andhra Pradesh judgment
The
has
Andhra
also referred to.
Himachal Lordship, yes. The petitioner referred to that Lordship at page number 4. And then the Honorable High Court at page number 6 in
So
that discussion.
let us assume 28 February is the specified date.
Lordships.
Let us lock it for the time being. So what will be the 3 months?
3 months forward.
You want to say that this interpretation is correct, right?
Lordships. That is what they say, 28 February 25, 3 months is 28th of November 24. Two other high courts, I have argued, Lordship, that are still interim orders. So I'm not placing again. Lordships will decide, Lordships will see. And
Right.
Well, Lordship, we cannot go into calculation. That is what the wisdom is. When month is there, it has to be calendar month. Had it been days, it can be 30th also, it can be 27th also. That calculation aspect cannot be gone into the statute now, Lordship, because the statute uses the word month. And that is the whole argument.
Okay, both of you find out, we keep it parted. If you don't fail, then I have to interpret. Because there is no instance this, if we go by the provisions of General Clauses Act, it does not throw you light. Month, section 235, it is okay, month. And calculation of period, that excluding the period, when you go forward, not going backward. So that is, there is no provision in the General Clauses Act.
But if it is a single month, my lord, there is no, my lord, at all dispute, my lord. Here it is a case of 3 months, my lord. That's why.
Now, here is a case of 3 months, but Rule 80, Rule 80 speaks about, it is not that
It is a date.
end of December.
It's a date.
It is a date. So from that you have to go backward for 3 months.
First forward 3 years and then backward
No.
3 months.
Rule 80 says a particular date.
Lordships.
Then from there, whether you have to go by a month or you have to connect yourself to the connected date, corresponding date in previous of the 3 months. So you have to connect these 3 months to the end of
That month or
November or to the corresponding date in November.
That whether it will be in the exception part of that, my lord.
I have to understand this. My English is not
Right, my lord.
that dots one. Can you find out the judgment?
Main judgment, my lord.
Mean judgment,
I will.
right?
That-
Because something is there.
I will find out. That I will find out.
My lord.
All this answer could be there.
Also, but we can find and give it to your
No,
lordship
no.
to decide.
After
We
reading
cannot
it,
interpret that.
after reading it, it looks like it is interesting judgment. That particular dots,
Lordships.
and that I have read
My lord.
exceptions
Yes.
and all. That you find out, or if it is possible,
I will.
place it. Okay. Heard Mr. A. Kanodia, Learned Counsel for the petitioner, and Mr. B. Gugoi, Learned Traditional Advocate General, and so in Sustaining Counsel, Finance and Taxation Department, for all the respondents. Those to place the case again as parted, immediately when you are
I- I-
available, Mr.
Lordship, I'm coming on 22nd
Okay,
or
22nd,
9th also I'm coming with.
9th?
9th of this month I'm coming.
No, 9th is not possible, 22nd.
20. And Lordship, in the meantime, they passed this demand order. They've again given a letter that it is stayed. Your Lordship can record that. Lordship, they passed an order signing. They have given a letter also that it will be stayed.
They've already said it will be stayed.
Well, Lordship, may kindly take into account.
That's the difficulty. He said that it is, my lord, it's not that by hand we are issuing it.
Lordship,
That's why it immediately letter issued that it will not be effective.
Well, it is signed by hand.
Okay, he's saying that, okay.
Already they have taken the.
Though Mr. Kanodia, Learned Counsel for a petition has submitted that demand order
Demand.
has been issued in the meantime, Mr. Gogoi. Learned so has submitted that the order
The order is.
is order dated
28th of February 25.
28th of February 2025, huh? Will not be given effect to.
They've already been ordered.
Huh?
They have given a letter to that extent. Because Lordship, they stated that we have not intimated the High Court order. We have acknowledgement that we have intimated the High Court order. I am not going into these aspects, Lordship. But these are acknowledgement that we carry that the High Court order was intimated to them. But in
Maybe this is not, then it is kept in abeyance till the decision of the Honorable High Court.
But the reason that they have given that they were not communicated, that is false, Lordship. I have the acknowledgement of communication.
Okay, these are unnecessary things.
These orders.
It is already kept in abeyance, like already kept in abeyance. Sometimes there may be bona fide mistake also, but when it is rectified, okay.
Grateful. So 22nd, your Lordship have posted.
22nd.
Grateful.
Ah.
Much.
The earlier interim order. Earlier interim. Shall continue. Till done.
Always a pleasure appearing here.
May please, Lordship, I'm sorry. Item number 38. I was in some danger
Okay.
position when my brother, younger brother met with the accident. I went to the WC court, then I got the information that I went to the higher hospital. I'm sorry to, well, in this case, 38, the deficiency of the court fee. Well, that was defected when I mentioned on 6/1/25. Then I rectified. Then I discussed with the Mr. Ojha, the filing section. Then he said that there is a 5 petitioner, he repaid individual. That I from the one, our High Court judgment division bench, because they are the all identical petitioner. So, read appeal number, this is my case. I did it, Mr. Prakash is there. 430 IA, WA 430/2023. So they said that we'll rectify it and send it. They send it, but I have not seen that. Now they have given that there is a deficiency. On that impression, I continue the case last 3 months.
Okay.
I'm sorry, my experience.
For hearing, item number 6.
Much obliged. ma'am.
Great pleasure, Lordship. This matter was also earlier taken up by Lordship.
Forgotten, everything forgotten.
Anyway,
I
I
don't have,
please the facts before you.
I remember that I
Yes, you're right.
had you for some time, looking at the file and looking at you, I can memorize that I have heard you, but what I have heard you,
Yes. Definitely, Your Lordship. Your Lordship, this is a matter where the
I think.
this is a matter.
Go slow.
It's a coke manufacturing factory company concerned where the petitioner number is the firm and the petitioner number 2 is the proprietor of that firm. What has happened? This establishment was set up in the in a plot of land, 2 bighas, 4 kathas, 4 lechas, I think. And what had happened? This factory was set up by him in his own plot of land.
Sole
Subsequently,
proprietor. Petitioner 2 is the sole proprietor.
yes, Your Lordship.
Okay.
Now, what had happened, after some time when this factory was being run, the Coal India authorities demolished the property with the assistance of the district administration and the police authorities. Normally, when there is a demolition or any sealing of such sort, the assistance of the district administration is normally taken. That is the route. Initially, when I objected to it, they did not listen to it, and ultimately it was demolished. Thereafter,
I think on the last hearing, something was
pertaining
discovered.
to the status of the land, whether the ownership of the land. Their claim, the Coal India authorities, they said that it was their land. Earlier, it was the land belonged to the Assam ART, Assam Railway Trading Company. Then after the nationalization of the coal mines in 1973, it was taken over by the Coal India authorities. So your Lordship also pointed out earlier that what is the status of the land. I had placed the Jamabandi copies and all, but then what had happened, your Lordship will kindly take note of Annexure 5, page 26. Jamabandi for surveyed village. Serial number 3, I am the petitioner number 2, Khitis Devnath. 2 bigha, 1 katha 4 lechas out of the dark number at 160. And in the
Page
remarks,
20,
page 26, your Lordship.
26, type
Of the
copy,
writ petition,
type copy.
type copy.
Assam Railway Trading Company,
Yes,
51. Khitis Devnath,
Khitis Devnath.
2 bigha, 1 katha, 4 less.
Yes. And in
Let
the
us
remarks,
read the
column,
remarks as per as this
as
is
per the
ordered.
SDC's order, it is such and such in mutation case number so and so, mutation in respect of so and so out of land out of the total area covered by DAG number so and so, NLR patta number so, Ledu Tikok. Number 2, NLR grant is allowed in favor of Khitis Devnath.
Possession,
Possession,
mutation.
mutation.
Who is the title?
This is the copy of the Jamabandi also.
Jamabandi is not.
No, I
title.
understand your Lordship.
So who is the title?
Now-
I asked you.
Yes, your Lordship.
Right
had asked
now,
me. Your Lordship recollects.
who is the title?
As regards the title, we have not been able to place much record. But so far as this present writ petition is concerned,
This
no.
is mutation
yes,
for the purpose of giving khazna.
yes, for the purpose of using khazna. Now, what I am saying is that this writ petition was filed on 2 counts. One is the contention that we have raised that it is my land and this setup that was set up in that plot of land belongs to the
To
petitioner.
tell it is my land as a title holder.
Yes.
Petition is deficient.
That is one limb of argument.
That is
Second limb
another
of
word is
argument-
possession.
Yes. Second limb of argument is this, your Lordship, that whether authority concerned, whether it is the Coal India or the district administration, can demolish the property without giving me an opportunity of being heard, whether there is violation of the principles of natural justice and all. Now, in this regard, I am, Lordship, relying on paragraph 15 of my writ petition at page 13. Paragraph 15, page 13. That your petitioner states that the respondent authorities in the district did not issue any show cause notice to the petitioners, nor the petitioners were afforded any reasonable opportunity of being heard in the matter before demolishing the structures of the petitioner's business premises. Then your Lordship will kindly come to page 15, paragraph 19. 15, page, paragraph 19. That your petitioner state that Article 300A of the Constitution of India provides that no person shall be deprived of his property save by authority of law. The state government cannot, by taking recourse to such executive power of the state, deprive a person of his property. Such power by the instrumentalities of the state can be exercised only by the authority of law and not even by mere executive fiat or order. Now, in the present case, assuming that it is not my plot of land, since I am in possession of it, the authorities of the Coal India authorities, the respondent authorities, would have given me a reasonable opportunity of hearing before demolishing the property concerned. Now, here is a case that opportunity was not given to me.
What has been demolished?
The factory where this business concern was established.
Any photograph?
Uh, Photographs have not been placed here. But in the affidavit in opposition, they have stated so. They have not denied. Your lordship will
Now,
kindly
what is you have said about the demolition?
regarding the demolition,
In the writ petition, what kind of demolition?
demolition of the business premises, your lordship. Your lordship will kindly come to paragraph 10 at page 10 of my writ petition. Page 10, your lordship. Paragraph 10. That taking advantage of the halt in the production of coke by the petitioner from the authorities in the district administration, that is respondent number 2, 3, 4, and 5, along with the respondent numbers 8, 9, 10, 11, and 12 respectively, who are the officials of Coal India Limited, Northeastern Coalfields, and their personnel visited the premises of the petitioner firm on such and such date at such and such time, and arbitrarily and illegally demolished the entire business establishment along with its structures and machineries standing thereon. This arbitrary and illegal action was initiated by the district authorities without issuing any prior show cause notice or any affording any reasonable opportunity of hearing to the petitioners in that regard prior to the aforesaid demolition. Now, your lordship will kindly come to the affidavit filed by the Coal India authorities.
Come to page 36. Where is a mention of district administration officials?
An executive magistrate and local police personnel were also present at the place of occurrence at that time.
Where is it?
Second paragraph, the last line. The second paragraph, the last line of the second paragraph. Page 36.
Case was registered.
They have stated in the.
Let us see what is the affidavit of respondent number 6.
Yes, your lordship.
When is the date of incident?
26/7/2013. Your lordship will kindly come to paragraph 4 of the affidavit filed by respondent number 6. The deponent was the inspector officer in charge, Margherita Police Station. In paragraph 4, has your lordship been able to lay hands in this particular?
So there is some order.
Yes,
There is some order.
order of the district magistrate for detailing the police personnel at the time when this demolition was
So
carried out.
demolition is not preceded by no order. There is an order.
But no, it is nobody's case that there was no order. The Coal India officials contacted the district administration and
So subdivisional officer civil Margherita
yes,
passed an order on
Yes.
23/7/2023
yes,
to provide security,
yes.
to maintain law and order
Law and order.
during the time of operation.
Yes,
Executive Mr. So-and-so executive is magistrate who has been detailed by the district magistrate to maintain law and order duty during the time of operation for demolishing coke bhattas of the petitioner and another. The order is carried out.
yes.
It is submitted that little.
Paragraph
Your
7.
FIR was registered.
Yes, your lordship.
Where is the order of the SDO civil?
SDO civil, your lordship, there is an affidavit also by respondent number 3.
Affidavit. Yes.
In paragraph 3, he has stated that the petitioner's name is found recorded at serial number so and so, along with the Pattadar on a plot of land measuring such and such. In paragraph 3, that is what he has stated.
Hmm.
Regarding the recording, the remarks that was recorded
Then-
in the Jamabandi.
Deputy Commissioner, why is order detailed people loss? During the time of operation demolishing of 2 coke bhattas, out of which one was owned by petitioner. In the light of the order, the chief divisional officer detailing people loss. Your time of operation. Demolition of coke bhattas. One B Ganesh was also there.
That is also, yes, there was
One B Ganesh.
B Ganesh.
And who is respondent number 2?
Respondent number 2, lordship. The Deputy Commissioner Tinsukia. On his behalf also, a affidavit was filed by one Susanto Kumar Datta, who was authorized to swear that affidavit. In paragraph 4, he has stated that a letter detailing one magistrate was issued to General Manager Northeast Coalfields, Northeast Coal, in response to his request for providing magistrate during demolition operation contemplated by NEC in the leasehold area of Tirap so and so so and so. The demolition was proposed and carried out by the Northeast Coal authorities as decided in the meeting presided by so and so so and so. It is nobody's case that demolition was not carried out, so far as the responding authorities are concerned.
No,
Demolition was
it is,
carried out.
it is also apparent that there was some previous deliberation.
Yes, that the deliberation was there.
Previous deliberation.
No, our contention is that there may be a deliberation. We are not denying that. Our submission is that before taking up that matter of demolition, in that deliberation, we should have been also a party to it for giving us an opportunity of hearing. That opportunity was bypassed in my humble submission, Your Lordship.
And what happened to your FIR?
That fate of the FR was not later on.
Because case was registered.
A case was registered.
What had happened to it?
That, of course,
Okay. Were anything in the record? Coal India has filed affidavit.
In paragraph 5 of their affidavit, they said the land upon which the petitioner firm was set up does not belong to the petitioner number 2 as claimed by the instant petitioners. And
Meeting
it
partner
belongs
number
exclusively
12
to NEC. Coal
is
India
a
Limited.
lawful owner. Now they have categorically stated in paragraph 6. That they are the owner,
Yes,
including the subject plot of land.
plot of land.
That is, anything is rebutted by supporting evidence by the petitioner.
We have placed those in our reply, we have stated, and thereafter we have.
No,
produced some,
anything in rebuttal that they are also not the owner.
We have nothing but as such, but then at the same time, we have placed the whatever materials were there in our possession. Subsequently, also in our affidavit, also we have stated so.
No, anything in rebuttal.
Exactly, nothing in support of that rebuttal.
Because they are also paying land revenue,
Yes,
like you. So both are equated so far as paying land revenue is concerned. Both are paying. Government is receiving
gaining.
from two persons, they are receiving.
No, my limb of argument is not only regarding the ownership of the land, who is paying the revenue and what is there.
So
as
next question, my question will be, if you are dispossessed and they being the suppose owner, are now in possession. By dispossessing you, they being the owner, right? And they are now in possession.
No, right now we are in possession.
Huh?
We are not in possession as here. We are not in possession as here.
They demolished it, they left it there and then.
Hmm.
Then subsequently, we remain in possession of that property, even till date. That is the instruction that we have.
Then
They restarted the oven.
Then what is there?
No, my question is this, Your Lordship.
Demolition. We are not going to that disposition when you got the position back.
Yes, now the thing is.
That assessment we are not doing.
No. What I am saying is this, Your Lordship. Regarding the contention that we have raised in the writ petition, that after the demolition also, the demolition that had taken place, it was without issuing any notice, without any opportunity of being heard. That is our moot question, whether they can do so. Assuming I am a trespasser.
Okay,
But
then it will be going against, something will be going against you now. Because you have failed to produce anything substantial except the Jamabandi. And now something will be observed because of the argument.
Because of the
argument, yes, this position and again position back. You have claimed now you are in possession. In the meantime, damage was done to your factory.
Yes, damage was done.
Okay. Yes. And for damage, you go to the civil court. We are not assessing it.
No, so the first thing is that is one part regarding going to the civil court for claiming compensation or whatever may. The very thing that the demolition itself that was carried out without getting an opportunity.
Okay, we'll hold it. We'll hold it. And we'll hold it that 15 days time should be given to the petitioner. Thereafter, the second petition can carry out the eviction. Because you are not the title holder. now all the new judgments, re-demolition will be put in place. He will be protected. All these new judgments by Justice Gavai versus Justice Chandrachud, by Honorable Justice Pardiwala, last 2 months, that you have to put on notice, then decide by passing a reasonable order. Thereafter, if he goes against you, give him time to vacate. So that is why I put the question to you, that are you pursuing this repetition? Hey, Pardiwala, go take it away. Yes, it was wrong. It was wrong without putting you on notice. So anything to be followed for disposing the petitioner, the authorities should follow the direction laid down in so and so. And so far as the damage caused,
Yes.
if it is surveyed, it will, petitioner has the appropriate forum. Because all these are surveyed, perhaps insured, perhaps. Is it
Original of-
insured? Was it insured?
That of
Your
course,
industry?
that at this moment, I am not be able to tell exactly whether presently it has been insured or not.
Yes. We'll try, or otherwise we'll continue, we'll dictate the course of the hearing only. Yes.
Here, it's not that they were not put to notice. We gave them legal.
Okay.
notice.
No,
Let us-
legal notice is one thing. The second part is that at the time before demolition, when the matter was brought to the attention of the
Let
district
us hear
administration.
him. Let us hear him. Then you can reply.
Your Worship, the legal notice they on page, at page 21
20
of our affidavit,
of your
running page 93.
page 21. Page 21. Oh, yes.
This was notice issued on 26th September 2012.
What will be the status of the land then? If the Coal India is the owner of the land, so it will be a premise, public premise.
Public premises.
So will it be a notice under the Public Premises Unauthorized Occupants Act?
Hundreds of cases pending.
Huh?
Hundreds of cases are pending in that land.
Do you have any estate officer?
We have.
You have. So is it a public premise? Say,
It is,
some public premises action.
it is a public premise.
It come within the definition of public premise. Then there has to be a notice under section 4.
In that event, yes.
Huh.
But here,
What is the definition of public premise? Public any premise belonging to or taken on lease or acquisition or on behalf of someone includes any manager which have been placed by the government, whether belonging to taken on any lease. Any corporation, right?
Yes.
Not being a company. You are under a central act.
under the central act, Coal Mines Act,
So anything, any land belonging to a corporation will be public premise.
public.
There is no doubt about it.
No doubt.
then any eviction,
Can be carried out under the time.
Hmm.
But at this, at that particular time, we didn't have the state officer. And we raised the complaints after giving notice to the petitioner.
Hmm.
And repeated requests were made. He continued to,
Hmm. Okay,
we enacted the patta also of the.
Hmm.
It is-
Patta to, in the annexer. Okay.
Affidavit dated 27 January 25.
So as a result of the operation after that situation is back to
Back again to the.
back again to same position.
He has liberty to remain
Hmm.
without vote.
Hmm.
But there are-
Section 4, Section 5, Section 6. Is it not?
That is then otherwise also, as far as the bhatta is concerned, that requires to be demolished otherwise also, because this is on, the coal also, the source of coal is also unknown.
Is it because of this repetition everything is halted or what? In the certificate that Annexer 1. Annexer 1 or Annexer B. Where is the land? Description. Dark number, patta number, village.
That is.
Village is Tikok. Tikok.
Number 2 NLL.
Number 2 NLR. Tikok number 2 NLR. Where is it? Number 2?
Serial number 11.
CL number 11. Okay. There is 2,819 bigha. All these are periodic patta.
Yeah.
Okay.
This land, all these lands,
Hmm.
belong to the erstwhile Assam Railway and Trading Company. Upon nationalization, it's been vested in Government of India. Vested in Government of India and handed over to Coal Mines Authority Limited. Subsequently, Coal Mines Authority, the name was changed to Coal India. And these coal mines in Margate area are Northeastern Coalfields, which is a unit of Coal India Limited.
Hmm, hmm, hmm.
Only problem which we have been facing for last few years in these matters. The government, for reasons best known to them, but these are the reasons. They're not mutating it in our name. They're taking the money from us for revenue. They issue notice to us, but they don't recognize us as the owners by giving the mutation.
Mutation.
It
Patta
is-
was there.
But all the pattas are under Assam Railway and Trading Company.
Okay. What is your stand in the affidavit?
We had after
Main
giving the-
paragraph, main paragraph. Erstwhile Assam Railways and Trading Company.
They're the ones who established
Okay.
the coal mines, the
Hmm.
railways and tea gardens in that area. The railway was also established by them. For the transportation of tea and coal.
Okay, then it is Coal Mines Authority Limited. Then again, Coal India Limited. Then Northeast Coalfield is 1 unit. Hmm. And you're paying that land revenue also, except the mutation. He has got the mutation. Okay.
The system now has become such, anybody approaching the DC's establishment. And whatever amount they pay, they get the so-called settlement. That is earlier Mubarak Ali cases there, which went to Supreme Court. They had to return the land. There are 2, 3 others. And then another one of very close friend and colleague of mine, A.B. Chaudhary. His father was a contractor of coal of some railway and trading company. And they were allotted a plot of land, and all these allotments of land were given as on license basis for the purpose of the functioning there.
License. Legal license.
And A.B. Chaudhary also, they had a large plot of land there. They had a labor colony there. I've been to this place before I started cases for Coal India. And ultimately that was demolished overnight also. That came to the High Court. That time it was Mr. Justice Ranjan Gogoi who gave the judgment, dismissed A.B. Chaudhary's case.
So your case is without notice.
Without notice.
Only
And in
notice
fact,
is
your
that legal
lordship-
notice.
Yes, your lordship, I have one more point to add. During the pendency of the writ petition in the last year, there's an order of the Honorable High Court directing the district administration to ascertain the ownership to find to make a
I
detailed
don't know,
survey of
that
the.
is in the interim stage perhaps, but now I have seen
No,
you
yes,
have
sir.
no right
No, what I am saying is that,
title.
there was a letter, a copy of which is with me now, with regarding report regarding WPC number so and so, that the present writ. With reference to the subject cited, I am to inform you that as per office record, land area of such and such of NLR grant number 2, patta number so and so is recorded in the name of the Royal Coal Products owner, Kshitij Devnath. However, no record is available in the office of the undersigned whether the concerned land falls within the schedule of the Coal Mines Nationalization Act 1973, more particularly in respect of Makum coalfields, can only be ascertained by the concerned authority, that is NEC, as the said land is not recorded in the name of Makum coalfields in the record of right. The present status of the said land is that a
He is
coke bhatta
deciding
still
on
run-
record of right. Record of right, it is nothing but khazna. Nothing
that
but
is what they
khazna.
say.
At least you should have rebutted this particular document. The statements, all these statements they have made on oath.
No, that
This
reply we
particular
have, your
state-
lordship.
What, where you have stated? What you have stated?
We have filed our reply.
Categorical statements. Your only basis is Zamabandi. And revenue receipt.
In paragraph 6 of my reply, I stated
Paragraph 6. Affidavit reply to the
Reply.
affidavit of opposition, paragraph 6.
Eighth line from bottom. I emphatically assert that I have right, title, interest, and physical possession of the land in question. The plea raised by the respondent company.
I also emphatically recite all the land of occupied by High Court is my land. Will it do? So we go by documents. title appears to be apparently absent. Possession was there, it indicates from the mutation order in Jamabandi. And now you were dispossessed
Yes.
and got yourself into possession again. Situation restored back to the position where it was. Only thing, collateral thing is that the damage was caused in your structures, factory structures, whatever. We don't know about the assessment. What is the assessment? If their action is illegal, it is up to you to
No.
go for damages.
No, for damages, that is one part, but my point is
And-
that whether the
But
very.
The other part, that prior notice
Yes.
was not there. So we hold that action was bad. Now you do this manner.
No, it is not their prayer that
No.
what should be done subsequently.
So
Your lordship
ought to have proceeded in this manner. So their earlier action was bad. So for that, if any damage is the petitioner is entitled to, he can approach the appropriate forum because court is ill-equipped.
Here in this regard,
Similar case, D. Ganesh name was here as a witness. He had also done a repetition here, he withdrew. It was dismissed for default, then he went to civil court. Civil court, after the Supreme Court, it was dismissed. And now it's pending, I think a second. issue
So
is pending here.
that is a disputed what kind of
yes.
damage
Dam-
was caused to the petitioner. And since he is making a prayer for 2 crores, court is well equipped, not well equipped to decide on that. So far as the disposition, act of disposition, the state has admitted, district administration, that we were present and there was order. And that was at the request of the Coal India authorities.
Yes.
Now, if it is a public premise, then the manner in which eviction is to be carried out
It was not followed.
has already been provided. An estate officer has to be appointed. He is to be heard. There he can lead first evidence that he has the title. If he fails, he goes. He goes. He goes back and baggage. I think that is a proper procedure. So the procedure adopted appears to be not followed.
Not followed, yes.
We've been adopting this procedure in the last few years. That time it was.
That time, but it ought to have been because it is an act of 1971. Right. Okay, we keep it part. I will dictate.
Your lordship, I am relying on few decisions. I do not know. Let me be recorded. In
On the
decision of
basis
Privy
of, if
Council
you
of
have any case
1924,
of public premises, yes.
uh,
It appears to be admittedly public premise according to them.
yes. As per the
According to you,
definition-
Jamabandi, and your own mutation order indicates possession, meaning thereby no sale deed. No sale deed,
Possessory right.
possession. So we'll act accordingly. Anything, please tell. Any Mr. Ahmed, anything more? Any,
We have citation also on the prison now.
yes, if you,
I am placing some citation.
not some, or 1 or 2.
Yes,
Don't burden,
only 4.
not 4.
One
But-
on regarding whether writ petition lies for enforcement of fundamental rights of a violation of the principles of natural justice. 1. Under that heading, I am placing one decision. The second is state cannot forcibly disposes by an executive order oblique fiat except under authority of law.
Now law is settled now, recent 3 decisions. Without prior notice,
Yes.
there cannot be.
So that I want to relay.
I think recent decision will be well sufficient enough. Anyway, if something comes out,
I am
which
relying
paragraph?
on a
Please
Privy
tell me.
Council decision also. It's a
Please,
compilation.
please mark it AKS Chaudhary, para. Otherwise I'll get mixed up. And Mr. Dotto, you mark it, Mr. Dotto, AM Dotto. Let me go through the brief. I am keeping it part heart, will not hear much, will just
Your
dictate
lordship
the
can,
order. No, it is
just
very difficult.
reserve.
Today I have reserved 32 judgments, so I will not. Before Bihu, I am not reserving. I have already reserved
No,
30. And I
Our anxiety was
I intend to give it before.
because it is a 2013 matter. Oh, you are-
That is why in the court itself. You will know what is being dictated.
It should come to a logical conclusion. That is my humble prayer.
Great prisoners.
I marked it. Did 11 portions.
Yes.
Your lordship is fixing
Monday.
it on another date, your lordship?
Monday, 3 o'clock will do. We'll put it at 3 o'clock, Monday. Let me go through the papers. We are dictating only. Nobody will be there.
Monday, Tuesday, Wednesday, 3 days.
If somebody here, I am not hearing you.
All 3 of us will be out.
Will it be
So
on Friday, your lordship?
this,
Next Friday,
Next one.
next 11th?
then we'll get the order after Bihu vacation.
Let it go, you'll have to have the question.
No, why stenographers will not be there. You have to see the other difficult. We put it on Monday.
10th,
10th. 10th is okay, your lordship.
Thursday.
Thursday.
Motions of this, no hearing.
10th, 3 o'clock? We'll listen. It's okay. No, 10th.
Those will be Muson days, mister.
21st. Whether 22nd of April suits your lordship.
Yes, hello, dear. Okay, let us put it on 10th. We'll make an effort. If possible, we'll do. Otherwise,
If not,
we'll
it will spill over.
roll over. Huh? Heard Mr. A.K. Chaudhary, Learned Counsel for the petitioners, and Mr. M.J. Ahmed, Learned Senior Counsel, estate by Mr. A.M. Dotto. Yes, Mr. Gusami. Learned Counsel for the respond number
8 to 12.
8 to 12. Also heard Mr. Okay, and Gusami. Learned Junior Government Book Assam for the respond number 1 to 7. First off, raise the case again on 10th as part that. The case will be taken up at 3.
Can we get
Only if it is very pertinent, then you point.
reflected at in the cause?
I don't think it will reach today.
I'll not take up today. You pick a date. After a review vacation, maybe preferably in the month of May,
May.
from 5th of May.
8th of fifth is Monday, 8th is. the
Yes,
Thursday.
8th, okay.
8th of-
Okay. Who is your opponent here?
KK Mohan.
You have informed.
Will it?
On the request of Mr. M.J. Ahmed, Learned Counsel, Senior Counsel. Stated by Mr. A.M. Dr. Learned Counsel for the petitioners in 14 and for the respondent Coal India Limited Authorities, list the cases on 8th May 2025. Yes.
Item 7.
Meet please, your lordship. Lordship, matter may pass over for the day.
For the day, it will for the month. Now, 14. Why?
Lordship, my.
As Boni,
Yes, lordship. My senior colleagues is lakes on court number 2, lordship.
Miss
F. Begum.
as Begum. Yes, Mr. Nandi, 2014.
14, and this is against the award of the permanent Lok Adalat.
Permanent Lok Adalat. On the ground of fraud.
This is regarding LIC policy lordship, regarding concealment of material facts. Then they went up to the ombudsman. The ombudsman rejected their claim. And then thereafter, they preferred in the permanent Lok Adalat at Karimganj. So the matter was settled and the award of the permanent Lok Adalat was complied with by us.
Okay.
And it was their alternative prayer that they should get the premium and in the print. So as for.
So, permanent Lok Adalat judgment can be challenged only on the ground of fraud. Otherwise, repetition is not maintainable.
Petition as per the judgment of the Honorable Apex Court in 2022.
Jalwar and all.
Yeah.
Jalwar and all, other Bhavna construction, all I think.
Yeah, 2012.
Ah.
CC.
Uh,
They can challenge by way of writ and on.
Suit.
because, against the award of the permanent Lok Adalat.
Ah.
Because this honorable court has under 226 and 227 can exercise the appellate jurisdiction. That is why they have kept.
Where Mr. Bonig is
Court number 2.
busy?
Court number 2, lordship.
I hope the
Court
action
number.
was come, lordship.
What else here?
If your lordship is
It's
adjourned-
Monday, Tuesday. If,
Your lordship,
if
I-
time
I-
permits,
maybe
Tuesday,
Can it be after before?
after a week.
Because I'm having some fixed matters there.
Okay. Miss
F. Begum.
Learned Counsel. Appearing on behalf of Mr. S. Bonig, Learned Counsel for the petition has made a prayer for adjournment, which is not objected to by Mr. K. Nandi, Learned Counsel for the respondent number LIC, respondent LIC. Full stop. As the repetition is of the year 2014, lays the case on side date of fixed date of hearing on DDO after view.
29.
Obliged.
Obliged, lordship.
Hmm.
Item 8.
Padmavati.
Padmavati construction.
Yes.
My lord, this is a case where there is tussle between two departments. One is PWD, another is NRHM. NRHM wanted to have a construction. They executed the work through PWD. The petitioner executed the work and got the amount. Then while the work is on, my lord, they issued an additional work order. Tiles, then wall putty, then a tube well. These are the 3 items. my lord. These 3 items, PWD issued the work order and petitioner executed it. Now, the NRHM in this affidavit said that PWD has not taken the approval from the NRHM. That is the small issue.
Hmm.
In fact, this case is covered by our High Court judgment Similar incident happened Malot in Navagraha, Mandir Mela. While constructing the road, the municipal authority Malot gave PWD some additional work. That work was not approved. Then that petitioner will approach this on the court.
This NRHM or NHM is an instrumentality of
Now,
the
now,
state.
now NHM Malot. At that
Is
point
an
of time, it was-
instrumentality of the state. Is it an instrumentality of the state?
I think
Meaning thereby is an entity under Article 12.
yes.
Huh?
Yes, Malot, it is.
Then Mr. Sharma, you get all of the judgment of the Supreme Court. There are two departments fighting in the court, High Court or Supreme Court, absolutely unwanted. One decision is there, followed by another. Two departments coming to the High Court and fighting between them is absolutely unwanted. We'll pass an order that on that basis. Whatever is there, it should be given to the petitioner and they fight it out wherever they want.
Yes, Malot.
You get hold of that? Mr. Chaudhary, Ms. Bora, fighting here, we do not want that. They fight in between departments writing letters, not before the court. This one. Today, actually, I'll not take up much.
Lots,
You get that if it's possible,
lots of.
Tuesday, we can do.
Lots.
Yes, Mr. Admittedly, work was given to the petitioner. Somebody or other from the respondent side, is it not? Now the dispute is the additional part.
Additional part.
Okay, what is your decision?
Lordship.
Citation?
Yes, Malot, this is High Court judgment, Malot.
You find out that one also. I hope you'll get it. Two departments of the government fighting before the High Court that will not agree to the other department. No, they are state. They represent state only. Nobody can fight between. There cannot be any fight between two departments before the High Court or the Supreme Court.
Get it.
Just that one. As Sharma, learned counsel for the petitioner, and Miss A. Bora. By standing counsel. Oh, it is there already.
Oh, it is.
Did you? Mr. B. Churil and standing counsel, PWD, for respond number 1. 4, 5. Miss P. Bora. Now standing counsel. A. Bora.
Standing culture, LHM.
And National Health Mission. For respond number 2 and Mr. N. Goswami. Junior Government Advocate Assam for the respond number 3 at present. As the repetition is of the year 2024, command lays the case on Tuesday and endeavor will be made to give final consideration to the repetition.
2014.
14,
Alright.
next Tuesday. Yes, Mr. Dotto, you are waiting. I don't.
Last Friday, my lord, any date, today is not possible. Item number 15, madam.
Oh, 15th, after Bihu then.
8th or 9th May.
No. Those
May,
will
May.
be, of May,
Yes.
not April.
No, April.
The other side, any private respondent?
No.
No. B. Dotto, Senior Counsel, stated by Mr. J. Das, Learned Counsel for the petitioner, G. Hazarika, Learned Standing Counsel, Revenue and Disaster Management for the state respondent. Anybody else? Oh, 1 and 2. And Goswami. 3 and 4. are present. Is the case on 8 May,
Right.
2025,
Interim order.
8/5. Interim order passed, shall continue. Who is for a private respondent otherwise?
Now the cause list, Mr. Bhaumik's name, JP Bhaumik, but they are not appearing. The last many occasions.
Okay. Any other case to be fixed?
Item 10, 11, 12. Lordship,
Yes.
grave urgency, otherwise,
Grave urgency.
my lord, earlier the impugn acquisition was under state highway. Now it is going to be national highway. This is the paper. So authority will be handicapped if it is not heard and disposed.
Hmm.
We are praying for setting aside that impugn section for notice and section 6 declaration. Up to that level, the proceeding went up. Interim order is operating in all the 3 writ petitions. It will be now.
Oh, no, what is your case otherwise in these petitions?
We are seeking setting aside of.
No, no,
section-
what is the background?
Oh, my lord, without, we did.
No,
not-
you have lands or what?
Yes, we are pattadars,
You are periodic patta holders.
periodic patta
Okay,
holders
then
with commercial
that,
lands also.
then thereafter what happened?
That section 4 notice, impugn section 4 notice, we did not receive. Neither of the 3 modes we got it.
Huh?
And behind the
Section 4, 1894
1890.
Act, Land Acquisition Act.
Yes, yes.
Okay, then what happened?
Then without hearing section 5A objection,
Huh.
section 6 declaration will made.
Huh,
At that stage, we approached before the Honorable High Court, we got stay order.
stay order.
Yes, in all the 3 writ petitions.
Lordship, we have published all the notices in all these papers, Lordship. And
That-
as we have not received any, no objection, Lordship, then we have proceeded.
Paper publication is
Yes,
made.
yes.
Then it is required to be examined. On what ground it was stayed?
On considering all the aspects, because
Any reason is recorded. Please tell me in the interim order.
a reason is on primary.
Simply state.
That illegality of the proceeding.
Any reason, detail order?
Not detail order.
No detail order.
But now authority will be affected because now national highway. So under National Highway Act, it will be done. by-
No, if the stay order is because by the High Court,
Yes.
we'll have to see from the,
On merit, Lordship. can
on
heard
merit,
it
on
edit.
merit. On merit we'll hear.
Lordship.
Not today.
Then on, if possible on 10th or
No, not
after
10th,
vacation.
not 10th. We'll
After
put
Bihu
it
vacation?
after Bihu, if Tuesday date.
After Bihu,
29 or 1st of April, May,
no, on 29th, I will be free.
1st of May,
1st of May,
good day.
good day, of course, but if in the meantime tender is
Oh.
fine,
You are having stay.
but
What worry?
but
There is no worry.
10 years old pending Lordship.
No, we are also,
Petitioners are
we are also concerned. That is why 1st of May, what is the problem?
all right.
Okay. Mr.
R. Islam.
R. Islam. For the petitioners, National Highway is also involved.
Yes, yes.
PWD. You are also.
Yes.
Beechwood Standing Council, PWD, and
Even-
Goswami, Junior Government Advocate Assam for the state respondents, Ms. G. Hazarika, Standing Council Revenue for the Revenue Department. We are not putting the respondents. And anybody else? NHA are present, non-standing council. NHA is found absent today on call, full stop. As agreed to by the Learned Council for the parties, lays the cases on 1st of May.
Interim orders passed earlier, sir.
The interim order, if any, shall continue till the next settlement.
That is deeply obliged. And endeavor shall be made to.
It is always our endeavor to
Lordship,
dispose
I
of.
have seen, Lordship is very logical, very
present in hearing that so far
I have to deal with some other cases also.
I have learned many things.
Oshuan,
Today.
I don't know, I am only student.